Sir, first question,
ಓದಿ
2023 paper, first question. The offences of stalking is punishable under section 354A IPC, 354B IPC, 354C IPC, 354D IPC, sir.
ಯಾವ್ದು ಆನ್ಸರ್?
D, sir, stalking.
ಸ್ಟಾಕಿಂಗ್ 354D.
D, 78 of BNS.
ಎಸ್, ಓಕೆ. ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಕ್ವಶನ್ ಓದಿ.
Second question, which of the following person is not entitled to maintenance under section 125 CRPC from a man who has sufficient means and refuses to maintain them? The man's wife, the man's illegitimate minor child, the man's father, daughter-in-law, sir.
ಯಾರು?
Daughter-in-law is not eligible, sir.
125 ನಲ್ಲಿ
125 CRPC.
ಎಸ್, ಮ್ಯಾನ್ಸ್ ವೈಫ್ ಎಂಟೈಟ್ಲ್ಮೆಂಟ್ ಇದೆ. ಸೊ ಮ್ಯಾನ್ಸ್ ಫಾದರ್ಗೂ ಇದೆ, ಇಲೆಜಿಟಿಮೇಟ್ ಚೈಲ್ಡ್ಗೂ ಇದೆ. ಎಸ್. ನೆಕ್ಸ್ಟ್ ಥರ್ಡ್ ಕ್ವಶನ್.
Who was the first president of the Republic of India, sir?
ಯಾರು?
Rajendra Prasad, sir.
ಎಸ್. ನೆಕ್ಸ್ಟ್ ಫೋರ್ತ್ ಕ್ವಶನ್.
Yes, sir. After completion of investigation, the police is to submit a final report to magistrate. The magistrate is not bound by conclusion drawn by police and may order further investigation, may issue a process against the accused persons bound by conclusion drawn by police and accept the same if police recommended that there is sufficient ground for further proceeding. Both A and C.
ಆನ್ಸರ್ ಯಾವುದು? ಆನ್ಸರ್ ಮೇಡಮ್, ಆನ್ಸರ್
A, sir. A, sir.
ಏನಾ? ಓಕೆ. ಅಂದ್ರೆ ಈಸ್ ನಾಟ್ ಬೌಂಡ್ ಬೈ ದಿ ಕನ್ಕ್ಲೂಷನ್ ಡ್ರಾನ್ ಬೈ ದಿ ಪೊಲೀಸ್. ಸೊ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಏನ್ ಮಾಡಬೇಕು? ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡಬೇಕು, ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ನೋಡಬೇಕು, ಸೊ ಮತ್ತೆ ಮಾಜರ್ ಇದ್ರೆ ಮಾಜರ್ ನೋಡಬೇಕು, ಮತ್ತೆ ಏನು ರಿಲೆವೆಂಟ್ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ನೋಡಬೇಕು, ಏನು ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ಎಲ್ಲ ನೋಡ್ಬಿಟ್ಟು ಹಿ ಹ್ಯಾಸ್ ಟು ಟೇಕ್ ಎ ಕಾಲ್. ಎಸ್ ಎಸ್ ಎಸ್. ಪೊಲೀಸರು ಏನೋ ಬರ್ದಿರ್ತಾರೆ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಅದನ್ನ ಫಾಲೋ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್
Fifth question. The defendant may seek leave to defend the suit upon appearance in a summary suit under order 37 of CPC. Within 30 days of service of summons, within 60 days of service of summons, within 90 days of service of summons, within 10 days of service of summons.
Answer is?
The correct answer is within 10 days of service of summons, sir. Interpleader suits.
Yes, yes, interpleader suit. Yes. Next, serial number 6th.
Who is the present Chief Justice of Supreme Court of India, sir?
ಏನು ಆನ್ಸರ್ ಹೇಳ್ತೀರಿ ಇದಕ್ಕೆ?
Justice Gawai, sir.
ಇಲ್ಲಿರೋರು ಯಾರು ಇಲ್ಲ.
ಇವ್ರಿರೋರು ಯಾರು ಇಲ್ಲ.
ಓಕೆ. ನೆಕ್ಸ್ಟ್ 7th ಕ್ವಶನ್. ಅಂದ್ರೆ ಈಗ ಇರೋರು ಕೇಳ್ಬೋದು ಇದೇ ಕ್ವಶನ್. ಈಗಿರೋ ಹೆಸರು ಕೊಡ್ತಾರೆ.
ಹೌದು ಸರ್.
ಓಕೆ. ನೆಕ್ಸ್ಟ್.
Where there are several defendants and one of whom dies after the matter was heard and reserved for judgment and judgment is pronounced, what happens? Proceedings abate as regards the dead defendant as cause of action does not survive on the other defendants. The judgment is a nullity as being passed against a dead person. The judgment is a nullity only as against the dead defendant. There shall be no abatement even if one of the defendant dies if death is between the conclusion of hearing and pronouncement of judgment, and judgment will be deemed to have been pronounced before the death of the defendant.
ಆನ್ಸರ್ ಯಾವುದು?
D, sir.
ಡಿ. ಒಂದ್ಸಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ರೆ ಮುಗೀತು. ಸೊ ಇಟ್ ಬೈಂಡ್ಸ್ ದಿ ಪಾರ್ಟೀಸ್. ಎಸ್. ನೆಕ್ಸ್ಟ್ ಕ್ವಶನ್ 8th.
Statement under section 161 of the Code of Criminal Procedure 1973 is required to be signed by the person making the statement. Is not required to be signed by the person making the statement. Is required to be signed by the person making the statement if it is recorded at the direction of the SHO. Is required to be signed by the person making the statement if it is so directed by the magistrate. Signature of the person making the statement is not required, sir.
Not required.
161 statement.
Yes, yes. Next, 9th question.
Where a decree is passed for the payment of money, the court can award interest on the principal sum adjudged from the date of the suit to the date of the decree under section 151 of CPC 34, section 35 of CPC, order 21 of CPC, sir.
ಆನ್ಸರ್ ಯಾವುದು?
34 interest.
34 ಇಂಟ್ರೆಸ್ಟ್ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ. ಸೊ ಅದ್ರ ಪ್ರಕಾರ ಮಾಡಬೇಕಾಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ 10th.
Vande Mataram was written by Subhash Chandra Bose, Surendranath Banerjee, Rabindranath Tagore, Bankim Chandra Chatterjee.
ಯಾರು?
Bankim Chandra
Bankim
Chatterjee,
Chandra Chatterjee.
Bengali writer.
Yes. Next, 11th question.
When A dies as a result of act or violence by person B, person C not present at the scene of crime can be prosecuted under the Indian Penal Code. Under section 120A to 120B of the IPC, under section 141 to 149 of Indian Penal Code, for act done in furtherance of common intention under section 34 of IPC, for vicarious liabilities as C was aware the offence was likely to be committed by B.
Answer ಯಾವುದು?
Yes, sir. 120A to 120B of the Indian
Criminal Conspiracy.
Criminal Conspiracy.
Yes. Next, 12th question.
12th question. A judgment can be passed taking note of admission of fact made in pleading or otherwise under which of the following provision?
Yes.
Under order 12 rule 6, under order 12 rule 4, under order 8 rule 3, under order 7 rule 10A of CPC.
Answer? Answer ಯಾವುದು?
Order 12 rule 6, sir.
Rule 6.
Admission ಮೇಲೆ
admission. Written statement ಅಲ್ಲಿ admission ಮಾಡಿದ್ರೆ, so based on the admission, judgment can be passed without there being any trial. Yes. Ultimately, it is left to the discretion of the court. Court has to take a call.
Yes.
Next, 13.
As per section 5 of Karnataka Rent Act 1999, in the event of death of tenant, right of tenancy shall devolve for a period of dash years from the date of the death of said tenant to his successors. 7 years, 5 years, 3 years, 1 year. Section 5, inheritability 5 years.
5 years ಅಷ್ಟೇ. 5 years ಇರುತ್ತೆ. Next, 14th.
14th. The fundamental right conferred under Article 19 of the Constitution of India is available to citizens of India, both citizens of India and foreigners, foreigners living in India also, all the above. Freedom, idu citizens of India matra, sir, not for others.
Yes, yes. Next, question number 15.
A tries to pickpocket B. B has a loaded pistol in his pocket. A's hand touches the pistol and triggers it, resulting in the death of B. A is guilty of B's murder. A is guilty of culpable homicide by negligence. A is guilty of grievous hurt. A is guilty only of pickpocketing. A is guilty of only pickpocketing. Mens rea element irodilla, sir.
Mens rea irodilla.
No negligence, no intention.
But resulting in the death of B.
So grievous hurt no illa, sir.
Yes.
Question 16. Section 164 of Code of Criminal Procedure 1973 statutorily mandates that a judicial magistrate shall record statement of the person against whom offence has been committed under any section of the Indian Penal Code for all offences punishable with life imprisonment in all cases where the accused moves an application for the said purpose for cases punishable under section 376 of Indian Penal Code.
Answer? 164 statement.
164 statement. Recording of confessions of offences for rape.
Okay. Answer ಯಾವುದು?
D ne, sir.
D. Right.
D for punishable under section 376 of IPC.
Yes, yes, yes. Next, 17.
In which of the following cases the offence of abetment is committed? X and Y attend reception of bride who was only of 13 years. Child marriage, sir.
Child marriage.
M officiates as priest or pandit in marriage of a girl aged 15 years and boy aged 12 years. Emperor were 12 years. Ex-widow prepares herself for sati and proceeds towards the pyre of her husband. X, Y, and Z follow her by shouting repeated Ram Ram. Only in B and C. Abatement.
Only in B and C.
B and C, sir.
Yes. Next. 18.
Compounding of an offense under section 320 of the Criminal Procedure Code 1973 as the effect of discharge, probation, acquittal, release on bail. Acquittal, sir. Probation illa, bail illa, discharge baroda.
Yes, acquittal. Next, 19.
Article 39A of the Constitution of India pertains to equal justice and free legal aid, equal opportunity in matters of public employment, equality before law, right of minorities to establish and administer educational institutions. Equal justice and free
Equal
legal
justice,
aid. Sir.
Free legal aid. Yes. Next. Question number 20.
Under section 311 of CRPC, a witness can be called on motion of defense, on its own motion by court, on the motion of prosecution, all the above.
All the above.
11 application.
ಯಾರು ಬೇಕಾದರೂ ಆಗ್ಬೋದು. ಅಷ್ಟು ಜನ ಮಾಡ್ಬೋದು. ಡಿಫೆನ್ಸ್, ಪ್ರಾಸಿಕ್ಯೂಷನ್, ಕೋರ್ಟ್ ಕೆನ್.
Yes.
Yes.
Who is the present speaker of Karnataka Legislative Assembly? UT Khadar, K.R. Ramesh Kumar.
ಇವರೇ ಇದಾರ ಈಗ?
ಇವರೇ ಇದ್ದಾರೆ ಸರ್.
ಓಕೆ ಓಕೆ ಓಕೆ.
ಕಾಗೋಡು ತಿಮ್ಮಪ್ಪ. Answer is UT Khadar, sir.
Right. Yes, yes.
Under section 468 CRPC, the period of limitation for an offense punishable with a term not exceeding 1 year is 1 year, 2 years, 3 years, 6 months. 1 ವರ್ಷ, sir.
1 ವರ್ಷ. Right. 23.
Which of the following are false? The plaint may be rejected where plaint does not disclose cause of action, where plaint is not filed in duplicate, where there is no compliance with Order 7, Rule 9 of CPC, none of the above. So, idರಲ್ಲಿ ಇದು ಮೂರೂನು ಟ್ರೂ ಇದೆ ಸರ್.
ಮೂರೂನು ಟ್ರೂ ಇದೆ, ಕರೆಕ್ಟ್.
So none of the above.
But none of the above, correct. None of the above is the answer. Yes.
A national leader whose birthday is observed as the National Education Day on November 11th is Shri J.B. Kriplani, Shri Rajiv Gandhi, Sarojini Naidu, Shri Maulana Abdul Kalam Azad.
Azad.
Sir.
Yes. Next, 25th.
Who is the executive head in India? The President, the Prime Minister, both A and B, either A or B.
ಯಾರಿದ್ದಾರೆ?
President is the head of
executive. Yes. Next. 26th.
Where the court finds, after hearing the parties under section 80 of CPC, that no urgent or immediate relief need to be granted in the suit, it may dismiss the suit, reserving liberty to file afresh after the notice as contemplated is served, may reject the plaint, granting liberty to file afresh after the notice period, may dismiss the suit as withdrawn, keeping all contentions open, may return the plaint for presentation after complying with the requirements of notice. Option is D, sir. The court has to return after.
Return, yes. Complaint ಆದ್ಮೇಲೆ ಫೈಲ್ ಮಾಡಿ ಅಂತ ಕಳಿಸ್ಬೇಕು ವಾಪಸ್. Next, 27.
And the government is a party to the suit, sir. Prior to 2 months notice.
Yes. 2 months notice. Yes.
Question 27. On a complaint for offences triable by court of session, after recording of statement of the complainant and his witnesses on oath, the police can be directed to investigation under section 202 CRPC. The police cannot be directed to investigation at all and magistrate has to conduct an inquiry. The police can be directed to investigation under section 156(3) CRPC, both A and B.
Answer is?
The police can be directed to do further investigations. 156.
156 ಅಲ್ಲ?
Really?
ಇದೆ. On a complaint for offense triable by court of session after recording of statement of the complaint and his oath.
Witnesses.
Yes. Yes. Next question.
which is the allied provision to Order 41 of CPC, Section 104 of CPC, Section 151 of CPC, Section
104, 151.
Order Roman number
46, 56,
10, 56, 56, 58. Order 58 of CPC.
Allied provision.
Allied provision. Section 151 deals with
yes.
inherent powers of the court.
ಇಲ್ಲ ಅದು independent ಇದಲ್ಲ section, allied section.
Allied section. This
allied
is
provision ಅಂದ್ರೆ section 104.
104, which Order 41, it deals with appeal, sir. Section 104 also deals with
appeal. That is the allied section.
Original.
Yes. Next.
In which of the following case the evidence given by the witness will not be relevant under Section 33 of the Indian Evidence Act 1872? When the witness is staying abroad, when the witness is dead, when witness cannot be found, when the witness is in coma.
ಯಾವ್ದು ರಿಲೆವೆಂಟ್ ಇಲ್ಲ? dead ಇದ್ದಾಗ ರಿಲೆವೆಂಟ್ ಇರುತ್ತೆ. It cannot be.
Declaration is relevant.
Yes, when witness cannot be found
is relevant.
He has gone missing. ಅವಾಗಲೂ ರಿಲೆವೆಂಟ್ ಇರುತ್ತೆ. When the witness is in coma, he cannot be called. ಸೊ ಈ ಮೂರು ಸಂದರ್ಭದಲ್ಲಿ ರಿಲೆವೆಂಟ್ ಇರುತ್ತೆ. ಅಬ್ರಾಡ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ರಿಲೆವೆಂಟ್ ಇರೋದಿಲ್ಲ. ಬರ್ಬೇಕು ಅವ್ರು ಆಕ್ಚುಲಿ. Yes.
Correct.
Answer is A.
A. As written in the preamble of the Constitution of India, one of the following is in the correct order. Secular, socialist, sovereign, republic, democratic. Sovereign, republic, secular, socialist, democratic. Sovereign, socialist, secular, democratic, republic. Republic, sovereign, secular, democratic, socialist.
ಇಂಕೋಟ್ರೆ ಹೆಂಗ್ ಬರೆಯೋದು?
ಸರ್ ಇದ್ರಲ್ಲಿ ಏನಾದ್ರೂ ಒಂದು ಇದು ಮಾಡ್ಕೋಬೇಕು ಸರ್, ನಿಕ್ ನೇಮ್ ತರ ಏನಾದ್ರೂ
ಮಾಡ್ಕೋಬೇಕು. ಅದೇ SSSDR ಅಂತ ಹಾಕೋಬೇಕು.
ಲಾಸ್ಟ್ ಅಲ್ಲಿ DR ಇರುತ್ತೆ ಸರ್.
DR ಇರುತ್ತೆ. ಅದೇ
SSD
DR ಆ ತರ ನೆನ್ಪಿಟ್ಕೋಬೇಕಷ್ಟೇ. ಕನ್ಫ್ಯೂಷನ್ ಆಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ 31.
31. Whether in a summons trial case instituted otherwise than upon a complaint, a magistrate of the first class can stop the proceedings and discharge the accused without pronouncing judgment. Option A, no magistrate must, after recording entire evidence, pronounce final judgment of conviction or acquittal. Yes, after evidence of principal witnesses has been recorded. Yes, for reasons to be recorded where evidence of principal witnesses has not been recorded. Yes, as a magistrate has discretion to discharge or acquit regardless of the stage of the proceedings.
Answer? Yes, he can.
Yes, sir.
The magistrate can stop the proceedings and discharge the accused. So after evidence of principal witness has been recorded. Yes. Next.
Which 30. of the following mortgage does not require a registration? Equitable mortgage or mortgage by deposit of title deed.
Yes.
Anomalous mortgage, usurpatory mortgage, mortgage by conditional
sale. Answer?
Equitable mortgage.
Equitable mortgage. Registration is not required.
Not required.
Yes. Next. 33.
Defense of intoxication to escape criminal liability. The intoxication administered against his will or knowledge shall not be self-administered, can be self-administered, all of the above. It should be against his will and without his knowledge. And
Correct. Yes. Next. 34.
Which of the following is false? Under Order 6, Rule 2, every pleading which includes plain and written statement shall contain evidence by which the material fact ought to be proved, statement in concise form of the materials relied upon for claim or defense, each allegation contained in separate paragraphs numbered consecutively, date, sums and numbers shall be expressed in the pleadings in figures as well as in words. ಪ್ಲೀಡಿಂಗ್ಸ್ ರೂಲ್ಸ್ ಇದೆ ಹೇಳ್ತಾರೆ ಸರ್.
ಅಲ್ಲ, ಈ ಫಾಲ್ಸ್ ಕೇಳ್ತಾರೆ. ವಿಚ್ ಆಫ್
False
ದಿ
ಕೇಳ್ತಿದ್ದಾರೆ.
ಫಾಲೋಯಿಂಗ್ ಇಸ್ ಫಾಲ್ಸ್ ಅಂದ್ರೆ
ಎವಿಡೆನ್ಸ್
ಎವಿಡೆನ್ಸ್ ಬೈ ವಿಚ್ ದ ಮೆಟೀರಿಯಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಆರ್ ಟು ಬಿ ಪ್ರೂವ್ಡ್, ದಿಸ್ ಇಸ್ ಫಾಲ್ಸ್.
ಫಾಲ್ಸ್.
ಯಾವ ಎವಿಡೆನ್ಸ್ ಇಂದ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕನ್ನೋದನ್ನ ಹೇಳ ಆಗಿಲ್ಲ. ಸೊ ಇನ್ ಮಿಕ್ಕಿದ BCD ಹೇಳ್ಬೇಕಾಗುತ್ತೆ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ.
Yes, sir.
ಎಸ್, ನೆಕ್ಸ್ಟ್.
As per the Karnataka amendment to section 54 of CPC, partition of estate or separation of share in executing a partition decree can be made by division by the Tahsildar, Deputy Commissioner, gazetted subordinate to the collector by the court. Amendment Act prakara by the court can do, sir.
ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಡೂ ಇಟ್, ಗೆಜೆಟೆಡ್ ಸಬಾರ್ಡಿನೇಟ್ ಇವಾಗೆಲ್ಲ ಅದು ಆಸ್ ಪರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಇದಾಗಿದೆ. ಎಸ್ ಎಸ್, ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಡೂ ಇಟ್. ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಬೈ ಅಪಾಯಿಂಟಿಂಗ್ ಎ ಕೋರ್ಟ್ ಕಮಿಷನರ್.
By appointing a court commissioner.
Yes, yes, yes. Next.
Which of the following section of the Indian Evidence Act 1872 has been amended by the Criminal Law Amendment Act 2013? Section 32, Section 55, Section 119, Section 124. Section 119, sir.
119 ಏನು?
Dumb witness, sir.
Dumb witness. Yes.
And it should be treated as a oral evidence.
Yes, correct. Next, 37.
Essential supply of service as defined under explanation 1 of section 49(5) of Karnataka Rent Act 1999 includes supply of water, electricity, lights in passage and on staircases, conservancy and sanitary services. Supply of water, electricity, lights. Supply of water, electricity, lights in passage and on staircase, road. Supply of water, electricity, lights in passage and on staircase. Correct answer A, sir.
A.
Conservancy, staircases, sanitary services, light, electricity, water.
Yes.
Next. Anticipatory bail. Next, sir. Anticipatory bail can be granted by the Sessions Court when the offense committed is bailable, when the accused has committed a non-bailable offense and has been arrested, when the accused it is alleged has committed non-bailable offense and is yet to be arrested, when the first information report has not been registered.
Answer is?
Not arrested, sir.
Not arrested and non-bailable irabekku.
Non-bailable offense.
Yes. C.
C is the correct answer.
Yes. 39.
Yes, sir. X and Y go to murder Z. X stood on guard with a spear in hand but did not hit Z at all. Y killed Z. Only Y is liable for murder of Z. X and Y both are liable for murder of Z. X is not liable as he did not perform overt act. Both A and C.
ಜೊತೆಲಿ ಯಾರೆಲ್ಲ ಹೋಗಿರ್ತಾರೆ ಅವರೆಲ್ಲ yes,
both X and Y both are liable for murder of Z. Option B is the correct answer.
Yes.
Question 40. As per section 122 of the Transfer of Property Act 1882, if the donee dies before the acceptance of the gift, the said gift is valid, void, voidable, illegal. The answer is void, sir.
Acceptance ಬೇಕೇ
ಬೇಕು gift.
ಸೊ ಹಂಗಾಗಿ void ಆಗುತ್ತೆ. Next, 41.
Who is the present Chief Justice of Karnataka High Court?
ಯಾರು ಇಲ್ಲ ಈಗ ಇಲ್ಲಿ.
ಈ ಊರಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಸರ್.
ಯಾರು ಇಲ್ಲ. ಈಗ ಯಾರಿದ್ದಾರೆ ಅವ್ರು ಬರ್ಬಿಡಿ.
ಸರ್.
Yes. Next, 42.
Accused wants to submit a document for consideration under section 35 of the Indian Evidence Act 1872. In which of the following cases will the document become irrelevant? It does not deal with fact in issue. It does not deal with a relevant fact. It is not an entry made in public or other official book register or record. It is not an entry made by public servant.
Answer is? Accused wants to submit a document for consideration under section 35 of the Indian Evidence Act. In which of the following cases will the document become irrelevant? So, it does not deal with the fact in issue. It does not deal with the relevant fact. It is not an entry made in public or other official book, register or record. It is not an entry made by the public servant. ಯಾವ್ದು ಆನ್ಸರ್?
C, sir. It is not an entry made in public or other official book, register or record.
Okay. So it is irrelevant. Because it is irrelevant, it is not made by the public servant, therefore it is not relevant ಅಂತ ಹೇಳದ.
ಹಾ ಸರ್.
ಇನ್ನೊಂದ್ಸಲ ಓದಿ ಕ್ವಶನ್. Accused criminal case ಅಲ್ಲಿ.
Accused want to submit a document for consideration under section 35 of Indian Evidence Act. In which of the following cases will the document become irrelevant? If it does not deal with the fact in issue, if it does not deal with the relevant fact, it is not an entry made in public or other official book, register or record. It is not an entry made by public servant. So section 35 deals with relevancy of entry in public record or an electronic record made in performance of duty.
Public duty.
Public duty. So C is the correct answer.
C is the correct answer. Yes. Next. 43.
Which of the following section of the Indian Evidence Act deals with proof of other official documents? Section 78, section 82, section 71, section 74.
Section
82, sir.
82 na? 82 alla. 78. 78 speaks about other public documents.
Other official documents.
Official documents. Yes. Other official documents ಅಂದ್ರೆ ಯಾವುದು?
Notifications, gazette notifications.
ಇಲ್ಲ ಅದಿಲ್ಲ ಅದು. ನೋಡಿ ಏನಿದೆ? ಬುಕ್ ಇದೆಯಾ?
ಇದೆ ಸರ್.
78 ಓಪನ್ ಮಾಡಿ.
ಇದೆ ಸರ್ 78 official documents. Order of notification of central government, state government.
Yes, I am confused. Correct.
Legislature proceedings, proclamations, journals, municipal body proceedings.
Yes. Right. Next, 44.
Public records.
Yes, 44.
In relation to first information report, which of the following statement is not correct?
Correct.
FIR. It is not a substantive evidence. It merely marks the beginning of the investigation. It cannot be used as a previous statement for any purpose. The informant need not be an eyewitness. So the correct answer is it cannot be used as a previous
statement
for any purpose.
Yes. Correct. Next. 45.
45. A instigates B, a child below 7 years of age, to set fire to a dwelling house. A is not guilty as there is no question of abatement of child. A is guilty of abating B to set fire. Can't say none of these.
Is abater.
Is an abater, sir.
Answer is
B.
B. Next.
As per Article 227 of Constitution of India, every High Court shall have superintendence over dash in relation to which it exercises jurisdiction. On subordinate courts throughout the territories, district courts throughout the territories, civil courts and tribunals throughout the territories, all courts and tribunals throughout the territories. Courts, tribunals throughout the territories.
Yes, territory. D. Next.
Before Memory Fades is an autobiography of Fali S. Nariman, Solis Rabji, Venkat Ramani, none of the above. Fali S. Nariman bardirod, sir.
Yes.
Before Memory Fades.
Yes. Correct. Next, 48.
48. A party wants to get the judgment set aside under section 44 of the Indian Evidence Act 1872. Which of the following circumstances he can do so? In case the judgment was passed by a superior court. In case the person challenging is a stranger to the proceedings. In case the judgment was a result of gross negligence. All of this.
A party wants to get the judgment set aside under section 44 of the Indian Evidence Act. In which of the following circumstances can you do so? If he is a stranger to the proceedings. In case the person challenging is a stranger to the proceedings. Yav the answer? ಏನ್ ಸೆಕ್ಷನ್ 44 ಏನ್ ಹೇಳುತ್ತೆ ನೋಡ್ರಿ?
Section 44, fraud or collusion in obtaining judgment or incompetency of court may be proved. Any party to a suit or other proceedings may show that any judgment, order, or decree which is relevant under section 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it or was obtained by fraud or collusion.
Yes, fraud, collusion, incompetency.
Incompetencies.
Idre that can be challenged. Yes, answer is B.
B.
Yes, next.
As per section 497 of IPC, a person commits adultery if he has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man without the consent or connivance of that man, such sexual intercourse not amounting to rape. Has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man with the consent or convenience of that man, such sexual intercourse not amounting to rape. As sexual intercourse with an unmarried man, as sexual intercourse with a married man.
Answer is?
Option is A, sir. Sexual intercourse without the consent of that man.
Yes.
Not amounting to rape.
Yes. Next. Serial number 50.
One of the following relief can be granted under the Specific Relief Act. Recovery of money, perpetual injunction, redemption of mortgage, ejectment of tenant. Relief B, sir. Perpetual injunction.
Perpetual injunction. Yes. Next.
Under order 38.
32. 33. 33.
Under order 33, rule 1A of CPC, an inquiry into the means of an indigent person can be made by the chief ministerial officer of the court. After the report is submitted under A, the court may adopt such report. The court itself make an inquiry into the question. The court may follow any of the above. Any of the above it can adopt, sir.
Yes.
Indigent person to check about his financial capability.
Yes. 52.
Relief of damages in a suit for injunction cannot be granted under section 40 subsection 2 of the Specific Relief Act 1963. Unless the plaintiff has claimed such relief in his plaint, if the suit of the plaintiff is dismissed, if the suit is frivolous, can be granted irrespective of whether the plaintiff has claimed the same or not. There shall be an express pleading in the plaint to claim a Specific Relief Act.
Correct.
ಅದಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಮೆಂಡ್ ಮಾಡಬಹುದು ಸರ್.
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬಹುದು. ಎಸ್. ಇಲ್ಲ ಅಂದ್ರೆ ಕೇಳಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ.
Under section 216 of CRPC, the court has the power to add to the charges already framed, alter the charges already framed, neither to alter nor to add to the charges already framed, add to and alter the charge, both. ಎರಡಕ್ಕೂ ಅದೊಂದೇ provision sir. Alter ಮಾಡಬಹುದು, add ಮಾಡಬಹುದು.
Yes.
In terms of order 20, rule 6A of CPC, the decree shall be drawn within 30 days of pronouncement of judgment, within 60 days of judgment, within 45 days of pronouncement of judgment, within 15 days of pronouncement of judgment. Within 15 days, sir. Decree has to be drawn from the date of judgment.
Civil rules of practice ಅಲ್ಲಿ ಎಷ್ಟಿದೆ? 15 days ಏನಾ? ಸಿವಿಲ್ ರೂಲ್ಸ್ ಅಲ್ಲೂ ಒಂದು ಪ್ರಾವಿಷನ್ ಇದೆ.
ಓಕೆ.
ಸೊ ಅಲ್ಲೂ 15 days ಇದೆ. Next. 55.
A foreigner stabbed B, another foreigner in a foreign vessel on the high seas. Both A and B were brought to Bombay for treatment where B died. A is also available in Bombay. Which one of the following propositions is correct in respect of applicability of IPC to the trial of A? As both the deceased and the accused belong to foreign countries and the occurrence of offense has taken place on the high seas, IPC is not applicable to A and hence it cannot be prosecuted in India. IPC is absolutely not applicable to a foreigner and hence A cannot be tried in India. As the offense is completed in India territory and accused A is available in India, IPC is applicable to A applicable and it should be tried to Bombay, tried at Bombay. As IPC is applicable to Indians as well as to foreigners, A must be tried in India. Or correct proposition ಕೇಳ್ತಿದ್ದಾರೆ ಸರ್.
ಯಾವ್ದು ಕರೆಕ್ಟ್ ಪ್ರೊಪೊಸಿಷನ್?
As first, sir, as both the deceased and the accused belong to a foreign countries and the occurrence of offense has taken place on the high seas, IPC is not applicable to A and hence it cannot be prosecuted.
ಅಲ್ಲ, ಅದೇನ್ ಹೇಳ್ತಾರೆ, ಹ್ಯಾಸ್ ಟೇಕನ್ ಪ್ಲೇಸ್ ಆನ್ ಹೈ ಸೀಸ್ ಅಂತಾರೆ. ಯಾವ ಹೈ ಸೀಸ್?
ಇದು ಹೈ ಸೀಸ್ ಮೇಲೆ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡೋ ಬದಲು ಫಾರಿನ್ ವೆಸಲ್ IPC is available.
Foreign country.
Foreign vessel belonging to
foreign countries.
So IPC is available to a vessel. ಎಲ್ಲಾನ ಇದ್ದು ಬಟ್ ರಿಜಿಸ್ಟರ್ಡ್ ಇನ್ ಇಂಡಿಯಾ ಇದ್ರೆ IPC is available.
Yes, correct.
ಆ ತರ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾಡ್ಕೋಬೇಕು.
ಈ ಕೇಸಲ್ಲಿ
A is the correct answer, sir.
A is the correct answer. A foreigner stabbed B, another foreigner in a foreign vessel. Okay, on the high seas. Both A and B were brought to Bombay for treatment, where B died. A is also available in Bombay. Which one of the following proposition is correct in respect of the applicability of Indian Penal Code IPC to trial of A? ಈಗ ಅದು ಫಾರಿನ್ನಲ್ಲಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿರೋ ವೆಸಲ್ಲೇ ಇರ್ಬೋದು, ಬಟ್ ಅದು ಎಕ್ಸಾಕ್ಟ್ ಎಲ್ಲಿ ಆಗಿರೋದು, ಪ್ಲೇಸ್ ಆಫ್ ಇನ್ಸಿಡೆಂಟ್
ಹೈ ಸೀಸ್. ಸರ್, ಇದು ಸೆಕ್ಷನ್ 4 ಆಫ್ IPC ಓದಿದ್ರೆ ಅರ್ಥ ಆಗುತ್ತೆ ಸರ್.
ಕರೆಕ್ಟ್. ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ಇದು ವೆಸಲ್ ಅಲ್ವಾ?
ಸರ್.
ಎಸ್,
ಸರಿ. ಸೆಕ್ಷನ್ 4 ಓದ್ಬಿಡ್ತೀನಿ ಸರ್.
ಓದಿ.
Section 4, extension of code to extraterritorial offences.
Yes.
The provisions of this code apply also to any offense committed by any citizen of India in any place without and beyond India. So any citizen of India ಅಂದ್ರೆ ಫಾರಿನರ್ ಆಗ್ತಾರೆ, ಬಿಯಾಂಡ್ ಇಂಡಿಯಾ ಲಿಮಿಟ್ಸ್ ಆಗುತ್ತೆ. Any person on any ship or aircraft registered in India wherever it may be.
Okay. ಅದೆಲ್ಲಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿ ಅದು ಎಲ್ಲಿ
ಬೇಕಾದ್ರೂ ಇರಬಹುದು, ಅವಾಗ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡಬಹುದು ಸರ್.
Yes. But this vessel is not registered with India.
It's a foreign vessel. ಈ ಮೂರನ್ನು ಇನ್ಕರೆಕ್ಟ್ ಆಗಿ ಬರುತ್ತೆ ಸರ್. With this principle I worked out. ಇದು ಮೂರನ್ನು ಇನ್ಕರೆಕ್ಟ್ ಆಗಿ ಬರುತ್ತೆ.
ಹಾಗಾದ್ರೆ ಆನ್ಸರ್ ಯಾವುದು?
ಏನೇ ಸರ್, ಚಾಟ್ GPT ಅಲ್ಲಿ ಹಾಕಿದ್ರು ಏನೇ ಬರುತ್ತೆ ಸರ್.
ಏನೇ ಬರುತ್ತಾ?
ಸರ್.
The offense is completed in India territories and accused A is available in India. ನೋಡಿ, offense is completed in India. offense ಎಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಆಯ್ತು?
ಇಂಡಿಯಾ ಸರ್.
ಇಂಡಿಯಾದಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಆಯ್ತಲ್ಲ, ಸೊ ಹಂಗಾಗಿ ಸಿ ಅಪ್ಲೈ ಆಗಲ್ವಾ?
C, as the offense is completed in
India
and accused A is available in India, this is applicable and he should be tried at Bombay.
ದಿ ಅಫೆನ್ಸ್ ಕಂಟಿನ್ಯೂಯಿಂಗ್ ಅಫೆನ್ಸ್ ಅಲ್ಲ, ಇಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡ್ಬಂದಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಸರ್, offense completed on high seas, whether the IPC is applicable on the water jurisdiction ಇದೆಯಲ್ಲ ಸರ್, so much of kilometers ಅಂತೀವಿ.
Yes, right. ಆಯ್ತು, A is the answer.
Sir.
Yes. Okay, next 56.
The plaintiff may unite in one suit different causes of action in terms of Order 1, Rule 2 of CPC, Order 1, Rule 3A of CPC, Order 2, Rule 3 of CPC, Section 24 of CPC. Yes, sir. Plaintiff can unite joinder of cause of action.
Joinder of cause of action, joinder of parties.
Order 2, Rule 3.
Rule 3. Yes, correct. Next.
Who is the present chairperson of Rajya Sabha? Nazma Heptullah, Hom Birla, Byron Singh Shekhawat, Jagdeep Dhankar. Jagdeep Dhankar ಇದ್ದಾರೆ ಸರ್.
ಎಲ್ಲಿದ್ದಾರೆ ಈಗ? ರಿಸೈನ್ ಮಾಡ್ಬಿಟ್ರಲ್ಲ. ರಿಸೈನ್ ಮಾಡಿದ್ದಾರೆ, ಈಗ ಬೇರೆ ಬಂದಿದ್ದಾರೆ. ಬಟ್ ಈ ಕ್ವಶನ್ ಪೇಪರ್ ಇದ್ದಾಗ ಅವರಿದ್ರು. ಮೊನ್ನೆ ಎಲೆಕ್ಷನ್ ಆಯ್ತಲ್ಲ,
ಚೇರ್ಪರ್ಸನ್ ಬರ್ಕೊಳ್ತೀರಿ ಸರ್.
CP ರಾಧಾಕೃಷ್ಣ.
Yes.
Yaar sir? Yaar madam?
CP Radhakrishna.
ರಾಧಾಕೃಷ್ಣ ಬರ್ಕೊಬಿಡಿ.
ಹಾ ಬರ್ಕೊಂಡು. Who among the following does not participate in the election of the President of India? Elected members of Rajya Sabha, elected members of Lok Sabha, nominated members of Rajya Sabha and Lok Sabha, elected members of Vidhana Sabha.
ಯಾರು?
Who will not participate, sir?
Yes,
nominated members of Rajya Sabha and Lok Sabha cannot participate.
Yes. Next.
When decree is passed ex parte against a defendant, he may apply to the court which has passed a decree for an order to set it aside under Order 9, Rule 9, under Order 9, Rule 11, under Order 9, Rule 13, under Order 9, Rule 14. Ex parte decree.
Ex parte decree.
Order 9, Rule 13, sir.
Yes. ಅಪೀಲ್ ಆಗ್ಬೋದಾ?
Ex parte decree.
Ex parte decree ಮೇಲೆ ಅಪೀಲು ಆಗ್ಬೋದು.
Appealable orders ಬಂದ್ರೆ
ಆಗ್ಬೋದು
ಸರ್.
ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ಇದನ್ನ ಹಾಕ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಅಪೀಲ್ ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಇದನ್ನ ಹಾಕ್ಬೋದು. Yes.
How a document will be proved under Section 61 of the Indian Evidence Act 1872? The contents of the document must be proved by primary evidence. The contents of the document must be proved by secondary evidence. Contents of the document must be proved by both primary and secondary evidence. The contents of the document must be proved either by primary or by secondary evidence.
ಯಾವುದು?
Either by primary or secondary evidence.
Yes.
Contents of document.
Yes. Next. 61.
A valid proclamation under Section 82 of CRPC 1972 requires a public reading of the proclamation in conspicuous place of town or village where the accused ordinarily resides. Copy of the proclamation should be affixed at some conspicuous place of the house in which the victim resides. Passed by the sessions judge, a copy of the proclamation should be affixed at some conspicuous part of the High Court of the state. A copy of the proclamation is affixed on conspicuous part of all police stations in the town village where the crime was committed.
ಯಾವುದು?
The correct answer is public reading of the proclamation.
In conspicuous place
of town or village where the accused
ಎಲ್ಲಿ ವಾಸ ಮಾಡ್ತಾನೋ ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು ಅದನ್ನ.
ಹಾ ಸರ್.
Yes. ಓದಿ ಅಂಟಿಸ್ಬೇಕು.
affix ಇದ್ರ ಜೊತೆ affixing ಮಾಡಬೇಕು.
Yes. Yes. Answer is A. Yes.
A was relieved of his breast watch worth ₹100 by B in a running train. When the train was about to stop at a railway station, A raised an alarm. At this point of time, C pushed A, as a result of which A fell down and sustained injuries. This was done by C to enable B to carry the stolen watch. C has committed the offense of hurt, grievous hurt, abatement of an offense, robbery.
ಯಾಕೆ?
Answer is robbery, sir.
ಯಾಕೆ ರಾಬರಿ ಆಗುತ್ತೆ?
The ingredient of injuries.
Injuries ಯಾವ, with what motive he has done?
For the other person to commit theft.
Yes.
Robbery, either extortion or theft should be present.
Yes. Next. 63.
As per Section 147 of Negotiable Instrument Act 1881, every offence punishable under the said act is non-compoundable, compoundable with the permission of the court, compoundable none of the above. It's compoundable. Court permission is not necessary.
Not necessary. Yes.
What can be the maximum interval between two sessions of either house of the parliament? 3 months, 6 months, 9 months, and 1 year. 6 months.
6 months. Okay. 65.
Article 85, sir. 6 months.
Yes.
In which of the following cases the court may presume under Section 114 of Indian Evidence Act that a man in possession of stolen goods after the theft is either the thief or has received the goods knowing them to be stolen? The judicial and official acts have been regularly performed. That evidence which could be and is not produced would, if produced, be unfavorable to the person withholding. The police withholding a piece of evidence, all of the above. ಅವ್ರೊಂದು ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಇಟ್ ಇಸ್ ಆಲ್
ಆ ಲಿಸ್ಟಲ್ಲಿ ಇವೆಲ್ಲ ಬರ್ತವೆ. ಇದ್ರ ಜೊತೆಗೆ ಇನ್ನೂ ಒಂದಷ್ಟಿದಾವೆ. ಎಸ್, ಇಟ್ಸ್ ಆಲ್ ಕವರ್ಡ್.
Which provision of the Criminal Procedure Code 1973 postulates that criminal courts would be open to which the public would generally have access, save in exceptional
cases?
Section 324, 327, 330, Section 333. Public access ಇರುವಂತ provision 327.
327. Okay. Next, 67.
Against perpetuity is provided in Section 14 of the Transfer of Property Act 1882.
Yes. Next.
1617 ಅಲ್ಲ sir.
Yes. 68.
The court has the power to permit a person or body of persons to present opinion or take part in the proceedings in terms of Section 92, Order 1 Rule 8, Section 151 of CPC, Order 1 Rule 8A of CPC.
ಯಾವ provision?
Sir, 92 public charities.
Public charities.
Order 1 Rule 8 representative suits. Section 151 inherent powers. Order 1 Rule 8, sir.
8A.
8A.
8A ಏನು ಹೇಳುತ್ತೆ?
To take part in proceedings.
Yes. Answer is D.
D.
Yes. Next.
Which of the following proceedings of the domestic tribunal and departmental inquiries, the Indian Evidence Act 1852 is not applicable? Officers conducting departmental inquiries, departmental proceedings, disciplinary proceedings tribunal. All of them.
Answer?
All of them, sir.
Okay.
Tribunals.
Yes.
The power of withdrawal and transfer by the High Court and District Court under Section 24 of CPC 1908 can be exercised only as regards suits, appeal, other proceedings, all of the above. Transfer of suits and withdrawal, all of the above.
All of the above.
Is with High Court and District Court, both the
yes,
courts.
General powers.
General powers.
Yes. Next, 71.
Once a mortgage, always a mortgage means mortgagee has no right to assign the mortgage debt to any other person. Mortgage cannot be redeemed after the expiry of a fixed period. Mortgage is always redeemable. Mortgager has no right to assign right of redemption to any person. Mortgage is redeemable.
Redeemable. It is always redeemable.
Always redeemable.
Yes.
In which country the 2010 Commonwealth Games were held? Canada, India, Britain, Malaysia. India, sir.
India. ಇಂಡಿಯಾದಲ್ಲಿ ಆಗಿರೋದಕ್ಕೆ ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ, ನನಗೆ ಕೊಡ್ತಿರಲಿಲ್ಲ.
Sir.
Yes.
Under Section 31 of the Specific Relief Act 1963, the cancellation of instrument can be granted only if the instrument is valid, only if the instrument is voidable, only if the instrument is void, if the instrument is void or voidable. If the instrument is void or voidable, sir.
Voidable. Yes. Yes. Next, 74.
Decision regarding disqualification of members of Lok Sabha are taken by Speaker, Prime Minister, Ministry of Parliamentary Affairs, Parliamentary Secretary. Speaker, sir.
Speaker ಅಂತಾರೆ.
Lok Sabha.
Next.
Which of the following is false? Under Order 6, Rule 16 of the 16, the court may at any stage of the proceeding order to be struck out or amended any matter in any pleading which is beyond the pecuniary jurisdiction of the court, which may be unnecessary, scandalous, frivolous, or vexatious, or which may tend to prejudice, embarrass, or delay the fair trial of the suit, or which is otherwise an abuse of the process of court.
False ಯಾವುದು? False. False statement. Which is beyond the pecuniary jurisdiction
of the court.
ಇದಕ್ಕೆಲ್ಲ ಪವರ್ ಎಕ್ಸೈಸ್ ಮಾಡ್ಬೋದು. ಸ್ಕ್ಯಾಂಡಲಸ್, ಅನ್ನೆಸರಿ, ಫ್ರಿವಲಸ್, ಎಂಬರಸ್ ಆಗದಿದ್ರೆ, ಡಿಲೇ ಆಗದಿದ್ರೆ, ಸೊ ಇಟ್ ಕ್ಯಾನ್ ಸ್ಟ್ರಕ್ ಡೌನ್ ದ ಪ್ಲೀಡಿಂಗ್ಸ್. ಅಕಸ್ಮಾತ್ ಎನಿಥಿಂಗ್ ವಿಚ್ ಇಸ್ ಅದರ್ವೈಸ್ ದ್ಯಾನ್ ಅಬ್ಯೂಸ್ ಆಫ್ ಪ್ರೋಸೆಸ್ ಆಫ್ ಲಾ ಅಂತಿದ್ರೆ ಇಟ್ ಕ್ಯಾನ್ ಸ್ಟ್ರೈಕ್ ಇಟ್ ಆಫ್.
Yes.
Next. 76.
Who is the legal advisor to the state government? Solicitor General, State Chief Legal Officer, High Court, Advocate General. Is the Advocate General at the state level, Attorney General at central
level.
Who is the present governor of Karnataka? T.C. Gehlot, V.V. Giri, S.N. Srinagesh, Chamarajendra Vadayar, sir. T.C. Gehlot, sir.
Gehlot. Okay.
The difference between section 34 and 149 IPC is section 149 is rule of evidence, whereas section 34 creates a specific offense. Section 34 requires active participation in action, whereas section 49 requires mere passive membership of unlawful assembly. Section 34 need not be joined with principal offense, whereas section 149 must be combined with principal offense. That whereas in section 34 there must be at least 5 persons, section 149 requires only
2 persons. Answer is
B, sir.
B. Section 34 requires active participation in action, whereas section 149 requires mere passive membership of unlawful assembly. Yes. Next.
Which of the following section 79, which of the following section of the Indian Evidence Act 1872 gives provisions regarding proof as to electronic signatures? 67, section 67, 67A, section 67B, section 67C.
ಯಾವ್ದಿದೆ?
67A ಇರ್ಬೇಕು ಸರ್.
ಎ ಇರ್ಬೋದು ನೋಡಿ. ಇವೆಲ್ಲ ಬರೆದು ಇಟ್ಕೊಬಿಡಿ. ಎ ಏನು, ಬಿ ಏನು, ಸಿ ಏನು. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅವರು ಬಿ ಕೊಡ್ಬೋದು ಅಥವಾ ಸಿ ಕೊಡ್ಬೋದು.
67A proof as to electronic signature.
ಸಿಗ್ನೇಚರ್. ಬಿ
ಸರ್ ಬಿ ಇಲ್ಲವೇ ಇಲ್ಲ ಸರ್.
ಇಲ್ಲ. ಸಿ
67B ಅನ್ನೋದೇ ಇಲ್ಲ ಸರ್.
ಇಲ್ಲ. ಓಕೆ. ಬಿನೂ ಇಲ್ಲ, ಸಿನೂ ಇಲ್ಲ.
ಸಿನೂ ಇಲ್ಲ. ಇದೆರಡು ಇಲ್ಲ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಎ ಓನ್ಲಿ ಅಲ್ವಾ?
67 is with regard to signature and handwriting of the person.
ಓಕೆ. ಬಿ ಸಿ ಎರಡೂ ಇಲ್ಲ, ಫಾಲ್ಸ್. ನೆಕ್ಸ್ಟ್ ಬಿ ಸಿ ಬರೆದ್ರೆ ನಮ್ಮ ಮಾರ್ಕ್ಸ್ ಕಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಬಹಳ ಓದ್ಕೊಂಡಿದ್ದಾರೆ ಇವರು ಅಂತ.
Section 80, the allied provision to section 114 of CPC is section 151 CPC, section 105 of CPC, order 41 of
41 ಅಲ್ಲದು. ಆರ್ಡರ್ 41. Yes, 41 of CPC.
41 CPC. 47 rule 1 of CPC. Section 114 deals with review petitions.
Review provision.
Provision 47.
47 rule 1. Yes.
In which state is the statute of equality situated? Telangana, Gujarat, Andhra Pradesh, Karnataka. Telangana, sir. Statute of equality. Ramanuja statue Hyderabad ಅಲ್ಲಿ ಲೊಕೇಟ್ ಆಗಿದೆ.
ಗುಜರಾತ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಯಾವುದು? ಸರ್ದಾರ್. ಅದು ಈ ಸ್ಟ್ಯಾಚ್ಯೂ ಆಫ್ ಲಿಬರ್ಟಿ ಅಲ್ಲ.
ಇಲ್ಲ ಸರ್.
ಲಿಬರ್ಟಿನೇ ಇರ್ಬೋದು. ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಒಂದ್ಸಲ.
ಮಾಡ್ತೀನಿ ಸರ್.
ಎಸ್. ನೆಕ್ಸ್ಟ್.
One of the following relief cannot be granted under the specific relief act. Redemption of mortgage, rectification of instrument, rescission of contract, cancellation of instrument. Redemption ಒಂದು ಬಿಟ್ಟು ಇನ್ನೆಲ್ಲಾನು
ಎಲ್ಲ ಕೇಳಬಹುದು. ಎಸ್.
The Indian Penal Code 1860 applies to an offence committed by a citizen of India outside India. Yes, no. If the offence is associated and has nexus with another offence committed in India, only if there is a mutual treaty between India and the country in which the offence was committed. Yes, sir.
Answer ಯಾವುದು?
A. Indian citizen ಎಲ್ಲಿ ಬೇಕಾದ್ರೂ ಇದ್ರೂನು he can be tried, sir. Extra territorial jurisdiction, section 4 IPC. Where the judgment debtor has paid the decree holder of a money decree outside court and a second suit is filed regarding the same amount, the court can reject such claim only where The judgment debtor produces the receipt signed by the decree holder. Statement is made by the witness of such discharge to the court. Except of passbook showing payment is produced. Record of adjustment or satisfaction of decree as recorded by the executing court is produced.
ಯಾವ್ದು ಆನ್ಸರು?
D, sir.
ಡಿ. ಗೊತ್ತಲ್ಲ ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆರ್ಡರ್ 21 ಅಲ್ಲಿ ಯಾವ ಮೆಥಡಲ್ಲಿ ಪೇ ಮಾಡ್ಬೇಕಂತೇಳಿ.
ಹಾಂ ಸರ್.
ಎಸ್. ನೆಕ್ಸ್ಟ್ 85.
85. Where an order granting injunction is passed without notice to the opposite party, then in terms of Order 39 Rule 3A of CPC, course of action to be followed by the court. Vacate the order of injunction automatically after 60 days. Should endeavor to dispose of the application within 30 days and failing which must record reasons. Upon expiry of 60 days, call upon the applicant to furnish security for the loss that may be sustained by the other side if the injunction is vacated, all of the above. Ad interim ex parte application to be disposed within 30 days.
30 days. 30 days ಅಲ್ಲಿ ಮಾಡಬೇಕಂತ ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
Endeavor to dispose.
Dispose.
Of. Not mandatory.
Not mandatory.
Only directory.
Direct.
Next.
The World Sparrow Day is observed on March 21st, March 23rd, March 25th, March 20th.
ಯಾವುದು?
20ನೇ ತಾರೀಕು ಸರ್, ಮಾರ್ಚ್
20.
To create awareness about the saving of sparrows.
Yes. Okay. 87.
87. An acceptance may be revoked in terms of Section 5 of the Indian Contract Act 1872 at any time before the communication of the acceptance is complete as against the acceptor, but not afterwards. After the acceptance comes to the knowledge of the promisee at any time at the option of the acceptor, all of the above. It can be revoked at any time before the communication of the acceptance is complete against acceptor.
Yes.
When India won the Cricket World Cup in 2011, who won the Man of the Series award? Sachin Tendulkar, MS Dhoni, Yuvraj Singh, Virat Kohli. Yuvraj Singh, sir. Super 6 over.
ಕ್ರಿಕೆಟ್ ಪ್ರಿಯರ ನೀವು?
ಇಲ್ಲ.
Okay. Next 89.
Which of the following statements hold true for dying declarations? Dying declarations cannot be used as a sole basis for confession. Dying declaration, unless corroborated, cannot be used as a sole basis of conviction. Dying declaration which is brief must be discarded. An eyewitness affirms that deceased was not in a fit state to make the declaration. The medical opinion cannot prevail. Answer is D, sir. D.
When eyewitness affirms that deceased was not in a fit
state of condition.
Yes, to make declaration. Medical opinion cannot prevail. Okay. Right. Next.
The Karnataka Loyakayukta Act was enacted in which of the following years? 1987, 1984, 86, 1990. 84, sir.
84. Okay. Next.
X and Y conspire to poison Z. X, in pursuance of the conspiracy, procures the poison and delivers it to Y in order that he may administer it to Z. Y, in pursuance of the conspiracy, administers the poison in presence of X and thereby causes death. What offense X and Y have committed? Both X and Y have committed the offense of criminal conspiracy. Since X has procured the poison, X has committed offense of murder and Y was an abettor. Both X and Y have committed the offense of murder. Y has committed the offense of murder.
Answer
is C, sir. Both X and Y have committed the offense of murder.
ಯಾಕೆ?
ಏನಕ್ಕಂದ್ರೆ ಅವ್ರಿಗೆ ನಾಲೆಡ್ಜ್ ಇದೆ ಸರ್.
Criminal conspiracy
is executed mens rea, element of mens rea.
Criminal conspiracy comes into play. Yes. 92.
Which section of the Indian Contract Act 1872 says that every agreement in restraint of marriage of any person other than a minor is void? Section 26, sir.
26. Yes. Next.
An employer deducting the employee's contribution under EPF and Miscellaneous Provision Act from wages payable for credit to fund but does not deposit the same with the fund, he is guilty of committing an offense Section 405, 378, 403, no offense.
ಯಾವುದು?
Criminal breach of trust, sir.
Criminal breach of 405. Yes.
94. The procedure to be followed by the court when there is a dispute as to the relationship of landlord and tenant between the parties stated in which of the following sections of the Karnataka Rent Act? Section 42, Section 43, 44 and 45. 43 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
43 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. Okay. Next. 95.
95. Definition of secondary evidence has been given under section dash of the Indian Evidence Act. Section 61, 62, 63 and 64.
ಯಾವುದು?
63, sir.
Yes.
62 primary evidence, 63
Yes.
is secondary evidence.
Right.
Under section 498A IPC, cruelty includes physical cruelty, mental cruelty only, cruelty by wife, harassment of women.
ಯಾವುದು?
Harassment of women, sir, by the relatives of the husband.
498A.
Sir.
Cruelty includes harassment of
women.
Physical cruelty only, mental cruelty only, cruelty by wife, harassment of women. Answer is harassment of women.
Women, sir. ಯಾಕಂದ್ರೆ cruelty includes both physical and mental.
Correct.
Wife, ಅದು not ground.
ಯಾಕೆ ಇಲ್ಲಿ only ಅಂತ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ?
ಸರ್ ಅದಕ್ಕೆ.
Yes. Answer is D.
D. Where there is fixed for where time is fixed for doing any act by the court may extend such time under section 148 of CPC by dash days, 45, 90, 120 days, not exceeding 30 days. Not exceeding 30 days, sir. Enhancement application.
Yes. Next.
Which is the largest state area-wise in India? Rajasthan, Maharashtra, Madhya Pradesh, Karnataka. Largest is Rajasthan, sir.
Rajasthan.
Smallest is Goa.
Okay.
Which section of the Negotiable Instrument Act 1881 states that the evidence of the complainant may be given him by on affidavit? Section 144, Section 145, 146, 147. 145 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ sir. Affidavit can be given by the complainant.
Accused ಕೊಡಬಹುದಾ ಬರೀ ಕಂಪ್ಲೇಂಟ್?
Accused ಕೊಡಬಹುದು sir. ಅದೇ provisional extended ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಬಟ್ ಅಲ್ಲಿ ಎಕ್ಸ್‌ಪ್ರೆಸ್ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ.
Express provision
ಇಲ್ಲ. 145 ಅಲ್ಲಿ ಬರೀ ಕಂಪ್ಲೇಂಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಜಡ್ಜ್ ಮೇಡ್ಲ ಅದ್ಯಾವುದೋ ಒಂದು ಡಿಸಿಷನ್ ಇದೆ, ಆ ಡಿಸಿಷನ್ ಪ್ರಕಾರ ಅಕ್ಯೂಸ್ಡ್ ಕೊಡ್ಬೋದು ಅಂತಿದೆ.
Again, it is the discretionary power of the court to allow such.
ಅಲ್ಲ ಡಿಸ್ಕ್ರಿಷನರಿ ಅಂತಾನೂ ಹೇಳಲ್ವಲ್ಲ ಅದು. ಇದು ಎಕ್ಸ್‌ಪ್ರೆಸ್ ಪ್ರಾವಿಷನ್ ಕಂಪ್ಲೇಂಟ್ಗೆ. ಸೊ ಮಿಕ್ಕಿದಕ್ಕೆಲ್ಲ ನೀವು CRPC ಫಾಲೋ ಮಾಡಬೇಕು. ಸೊ ಇಟ್ಸ್ ಕ್ರಿಮಿನಲ್ ಇನ್ ನೇಚರ್. CRPC ಫಾಲೋ ಮಾಡೋದಿದ್ರೆ ಅಲ್ಲಿ ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಕೊಡ್ಬೇಕಂತಿದೆ. ಸೊ ಹಾಗಾಗಿ ಕಂಪ್ಲೇಂಟ್ಗಂತಾನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ, ಇಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಆಫ್ ದಿ ಕಂಪ್ಲೇಂಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಕ್ಯೂಸ್ಡ್ ಇಲ್ಲ. ಇಲ್ಲಿಲ್ಲ. 145 ಸೆಕ್ಷನ್ ಈಸ್ 145 ಕರೆಕ್ಟ್. ನೆಕ್ಸ್ಟ್ ಓದಿ 100.
ಸರ್ ಅಕ್ಯೂಸ್ಡ್ಗೆ ಎಕ್ಸ್‌ಪ್ರೆಸ್ ಪ್ರೊವಿಷನ್ ಇದೆ?
ಇಲ್ಲ, ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಓದಿ, ಇದೆಯಾ ಪ್ರೊವಿಷನ್?
Sir, 145 subsection 2, the court may, if it thinks fit and shall on the application of the prosecution or the accused, summon and examine any person giving evidence on affidavit as to the facts contained.
Okay. Yes. There is express provision. Correct. ಕೊಡಬಹುದು ಬಿಡಿ. Yes, right. Next.
Which section of the Negotiable Instrument Act 1881 deals with effect of material alteration of the negotiable instruments? Section 85, 86, 87 and 88. 87, sir.
87. ನೋಡಿ, ಈ ಪೇಪರ್ಲಿ ಜಾಸ್ತಿ ಪ್ರಾವಿಷನ್ ಮೇಲೆ ಇದೆ ಅಲ್ವಾ? ಪ್ರಾವಿಷನ್ ಎಲ್ಲ ನೆನ್ಪಿಟ್ಕೋಬೇಕು ನೀವು.
ಸರ್.
ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಕ್ವಶನ್ ಪೇಪರ್ ತಗೋಣ.
ಸರಿ.
ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಬ್ರು ಯಾರಾದ್ರೂ ಓದಿ.
ಸರ್.
ಯಾರು ಓದ್ತೀರಿ? ಸುನೀತಾ, ಲಕ್ಷ್ಮಿ, ಸುಭಾಷ್, ಜಾರ. 21 ತಾಡಿ, 21 ಕ್ವಶನ್ ಪೇಪರ್. ಯಾರು ಓದಲ್ವಾ? ನೀವು ಯಾರಾದ್ರೂ ಮಾತಾಡಬೇಕು. ಲಕ್ಷ್ಮಿ, ಸುನೀತಾ, ಜಾರ, ಸುಭಾಷ್, ಯಾರು ರೆಡಿ ಇಲ್ಲ.
ಸರ್ ನಾನೇ ಓದ್ತೀನಿ ಸರ್.
ನೀವೇ ಓದ್ತೀರಾ?
ಎಕ್ಸಾಮ್ ಇದೆ.
ಅಲ್ಲ, ಅಟ್ಲೀಸ್ಟ್ ಅವ್ರ ಲೈನಲ್ಲಿ ಇದಾರಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ.
ಸರ್ ಅದೇ ಅವ್ರ ಲೈನ್ ಅಲ್ಲಿ ಇದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ ಆಫ್ ಹೆಲ್ಪ್ಫುಲ್ ಫಾರ್ ದ
ಕರೆಕ್ಟ್.
ಅಂದ್ರೆ ಸುಮ್ಮನೆ
ನೀವು ಓದ್ಬೇಕು, ನಾನು ಕೇಳಿಸ್ಕೋಬೇಕು. ಇಲ್ಲಿ ನೀವು ಟೀಚರು, ನಾನು ಸ್ಟೂಡೆಂಟ್ ಆಗಿದ್ದೇನೆ. ಯಾರು ಮಾತಾಡ್ತಾರೆ?
ಇಟ್ಟಿದ್ದೆ ಸರ್. ನಾನು ಆಕ್ಚುಲಿ ಇವ್ರಿಗೆಲ್ಲ ಹೆಲ್ಪ್ ಆಗುತ್ತೆ ಅಂತಾನೆ ರೀಡಿಂಗ್, ನನ್ಗೂ ರಿವಿಷನ್ ತರ ಆಗುತ್ತೆ. ಅವರೆಲ್ಲ ಇದ್ರೆ ಐ ಆಮ್ ರೆಡಿ ಟು ರೀಡ್.
ಕರೆಕ್ಟ್. ಬಟ್ ಯಾರು ರಿಯಾಕ್ಷನ್ ಇಲ್ವಲ್ಲ?
ಇದೀನಿ 21 ಇಲ್ಲ ಸರ್, 22 ಇದೆ ಅನ್ಕೊಂತೀನಿ
ಅಂತ ಹೇಳಿ, ಯಾವ್ದಿದೆ ಅಂತ ಹೇಳಿ. 21
ಅದು ನೋಡ್ತಾ ಇದೆ. ಬಿಫೋರ್ ದಟ್ ಸರ್, ಲಾಸ್ಟ್ ಮ್ಯಾಮ್ ಓದಿದ್ರಲ್ಲ 23 ಅಲ್ಲಿ ಇದು ವಿಚ್ ಸೆಕ್ಷನ್ ನೆಗೋಷಿಯಬಲ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಆಫ್ ಸ್ಟೇಟ್ ಎವಿಡೆನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಮೇ ಬಿ ಗಿವನ್ ಬೈ ಹಿಮ್ ಆನ್ ಅಫಿಡವಿಟ್ ಅಂತ. ಅದು ಅಂದ್ರೆ ನನಗೆ ಗೊತ್ತಿರಂಗೆ ಕಂಪ್ಲೇಂಟ್ ಅಷ್ಟೇ ಅಕ್ಸೆಪ್ಟ್ ಆಗುತ್ತೆ ಅಂತ ಸರ್.
ಯಾವುದು?
ಅದೇ ಸರ್ 145 ಮೇಡಮ್ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ರು, ಅಕ್ಯೂಸ್ಡ್ ಬರುತ್ತೆ ಅಫಿಡವಿಟ್ ಅಂತ ಅಂದು.
ಅಲ್ಲ, ಪ್ರಾವಿಷನ್ ಓದಿದ್ರಲ್ಲ, ಪ್ರಾವಿಷನ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ.
ಬಟ್ ಪ್ರಾವಿಷನ್ ಹೇಳಿದ್ರು ಸರ್, ಬಟ್ ಅದು ಕೋರ್ಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡೋದು ಸರ್ ಕಂಪ್ಲೇಂಟ್ ಅಷ್ಟೇ ಸರ್.
ಅಲ್ಲ, ಕೋರ್ಟ್ ಬಿಟ್ಬಿಡಿ, ಪ್ರಾವಿಷನ್ ಇದ್ಮೇಲೆ ಅವ್ರು ಮಾಡ್ಲೇಬೇಕು. ಮೇಡಮ್ ಇನ್ನೊಂದ್ಸಲ ಓದಿ ಅದು 145
ಸೆಕ್ಷನ್ 145 ಸರ್ ಫುಲ್ ಓದ್ಬಿಡ್ಲಾ ಇಲ್ಲ ಎರಡನೇದು?
ಫುಲ್ ಓದಿ.
ಸೆಕ್ಷನ್ 145 ಎವಿಡೆನ್ಸ್ ಆನ್ ಅಫಿಡವಿಟ್ notwithstanding anything contained in the code of criminal procedure, the evidence of the complainant may be given by him on affidavit and may, subject to all just exceptions, be read in evidence in any inquiry, trial or other proceedings under the said act. Subsection 2, the court may, if it thinks fit and shall, on the application of the prosecution or the accused, application prosecution ಅವರಾದ್ರೂ ಹಾಕ್ಬೋದು, accused ಅನ್ನ ಹಾಕ್ಬೋದು ಸರ್, summon and examine any person giving evidence on affidavit as to the facts.
Correct. As per this provision, ಅಲ್ಲಿ affidavit ಅಂತ ವರ್ಡ್ ಬಂದಿರೋದ್ರಿಂದ, so accused can also file affidavit. Yes, ಮಾಡ್ಬೋದು.
ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್ ಸರ್, ಕೋರ್ಟ್ ಕೆಲವೊಂದು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡುತ್ತೆ, ಕೆಲವೊಂದು ಮಾಡೋದಿಲ್ಲ.
ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್ ಅಕ್ಯೂಸ್ಡ್ ಗೆ, ಬಟ್ ಕಂಪ್ಲೇನೆಂಟ್ ಗೆ ಅವ್ರ ಅಫಿಡವಿಟ್ ತಗೊಳ್ಳೇಬೇಕು,
ಮ್ಯಾಂಡೇಟರಿ.
ಕ್ಲಾರಿಫೈಡಾ?
ಆನ್ಸರ್ ಬಟ್ ಅದೇ ಸರ್, ನಾನು ಕೇಳಿರೋ ಪ್ರಕಾರ ಕಂಪ್ಲೇಂಟಿಗೆ ಅಷ್ಟೇ ಅಂತ ನಾನು ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ, ಅದನ್ನ ನೋಡ್ಕೊಂತ ಕೂತೆ.
ಎಸ್. ಓಕೆ, ನೆಕ್ಸ್ಟ್ ಯಾವ ಪೇಪರ್ ಐತೆ ನಿಮ್ಮ ಹತ್ರ?
ಸರ್ ಅದೇ 22 ಇದೆ ಸರ್ ಗ್ರೂಪ್ ಅಲ್ಲಿ, ಅದನ್ನೇ ನೋಡ್ತಾ ಇದ್ದೆ ಸರ್.
ಓಕೆ, ಓದ್ತೀರಾ?
ಸರ್ ಆಯ್ತು ಸರ್, ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿ, ನನಗೆ ಎಷ್ಟು ಗೊತ್ತಿದೆ ನಾನು ಹೇಳ್ತೀನಿ.
ಎಸ್, ನೀವು ಓದಿದ್ರೆ ಸಾಕು, ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡೋದು.
ಶೋರ್ ಸರ್, ಓದಿ. ದ ಕಂಟೆಸ್ಟ್ ಆಫ್ ದ ಪೋಸ್ಟ್ ಆಫ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾ ಫಾರ್ ವಿಚ್ ಎಲೆಕ್ಷನ್ ಬಿ ಹೆಲ್ಡ್ ಟುಮಾರೋ, ದಟ್ ಈಸ್ 18/7/2022 ಅಲ್ಲಿ ಸರ್.
ಒಂದು ನಿಮಿಷ, ನಾನು ಒಂದು ಕ್ವೆಶ್ಚನ್ ಪೇಪರ್ ಓಪನ್ ಮಾಡ್ಕೊಂಡ್ತೀನಿ.
2022 ಇದೆ ಸರ್ ಅದು.
22 ಓದಿ.
ಫಸ್ಟ್ನೇ ಕ್ವಶನ್ ಸರ್, ದ ಕಂಟೆಸ್ಟರ್ಸ್ ಆಫ್ ದ ಪೋಸ್ಟ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾ ಫಾರ್ ವಿಚ್ ಎಲೆಕ್ಷನ್ ವಿಲ್ ಬಿ ಹೆಲ್ಡ್ ಟುಮಾರೋ, ದಟ್ ಈಸ್ 18/7/2022. ದ್ರೌಪದಿ ಮುರ್ಮು ಮತ್ತೆ ಜಶ್ವಂತ್ ಸಿಂಗ್, ದ್ರೌಪದಿ ಮುರ್ಮು ಮತ್ತೆ ಯಶವಂತ್ ಸೇನಾ, ರಾಮನಾಥ್ ಕೋವಿಂದ್ ಅಂಡ್ ಮೀರಾ ಕುಮಾರ್, ಶರದ್ ಪವಾರ್, ಶ್ರೀ ವೆಂಕಯ್ಯ ನಾಯ್ಡು. ಆನ್ಸರ್ ಬಂದ್ಬಿಟ್ಟು ಬಿ ಸರ್, ಅದು ಬಿ ಇದೆ ಸರ್.
ಎಸ್, ರೈಟ್.
An application to set aside abatement of the suit has filed under section 2. An application to set aside the abatement of the suit as filed under ಡ್ಯಾಶ್ ಆಫ್ CPC 908 ಸರ್. ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್. CPC ನಾನು ಪ್ರಿಪೇರ್ ಆಗಿಲ್ಲ.
ಹೀಗಾಗಿ ಹಿಂಗೆ ಮೇಡಮ್ ಯಾವುದು?
ಅದೇ ಮೇಡಮ್ ಹೇಳಿ ನೀವು ಅದು.
ಹೇಳ್ತೀನಿ ಮ್ಯಾಮ್ ನಾನು. ಸರ್, ಸೆಟ್ ಅಸೈಡ್ ಆಫ್ ದ ಅಬೆಟ್ಮೆಂಟ್ ಆಫ್ ದ ಸೂಟ್ ಪ್ರಿವೇಲಿಂಗ್ ಪ್ರೊವಿಷನ್ ಆರ್ಡರ್ 22 ರೂಲ್ 9.
ಎಸ್.
ಓಕೆ.
ಕರೆಕ್ಟ್.
ಓಕೆ.
ಲಿಮಿಟೇಷನ್ 30 days ಮೇಡಮ್.
ನೆಕ್ಸ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಮೇಲೆ ತರಲಿಕ್ಕೆ ಲೀಗಲ್ ಏರ್ಸ್ ಅನ್ನ ಆರ್ಡರ್ 22 ರೂಲ್ 3.
ಓಕೆ.
ನೆಕ್ಸ್ಟ್ ಓದಿ.
As per the Specific Relief Act 1963, specific relief can be granted for the purpose of enforcing individual civil rights, for the purpose of enforcing penal law, both A and B, none of the above, both A and B, sir.
ಇಲ್ಲ ರಾಂಗ್.
Sorry, A, sir. For the purpose of enforcing individual civil rights ಅಷ್ಟೇ.
ಬರೀ ಸಿವಿಲ್ ರೈಟ್ಸ್ ಅಷ್ಟೇ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಪೀನಲ್ ಗೆ ಬರೋದಿಲ್ಲ ಅದು ಸ್ಪೆಸಿಫಿಕ್ ರಿಲೀಫ್ ಆಕ್ಟ್.
ಓಕೆ ಸರ್. ಓಕೆ.
ಎಸ್. ನೆಕ್ಸ್ಟ್ 4.
As per Section 2G of Indian Contract Act 1872, an agreement not enforceable by law is set aside void.
ಏನು
ಅಗ್ರಿಮೆಂಟ್ ಸರ್? ಅಗ್ರಿಮೆಂಟ್ 2G.
ಆಯ್ತು, ಹೇಳಿ ಯಾವುದು? ವೈಡ್
ಸರ್. ವೈಡ್
ನಾಟ್ ಎನ್ಫೋರ್ಸಬಲ್.
ಎಸ್ ಸರ್.
ಎಸ್. ನೆಕ್ಸ್ಟ್
Wide rent agreement dated 1/2/2019. A let out is house property to B for residential purpose. A issued notice on 1/4/2020 terminating the tenancy of B. B received the said notice 4/4/2020. 15 days time for termination of tenancy start from 4/4/2020 sir.
ಯಾಕೆ?
ಅದೇ ಸರ್, ಒಂದು ನೋಟಿಸ್ ಯಾವತ್ತು ಇಶ್ಯೂ ಮಾಡಿರ್ತಾನೋ ಅಲ್ಲಿದ್ದ 15 days ಒಳಗಡೆ ಟರ್ಮಿನೇಷನ್ ಮಾಡ್ಕೊಂತಾರೆ.
ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿದ್ದಲ್ಲ, ರಿಸೀವ್ ಮಾಡಿದ ಡೇಟ್ ಇಂದ.
ಓಕೆ ಸರ್. ಓಕೆ ಸರ್.
ರಿಸೀವ್ ಮಾಡಿದ್ದು 4/4/2020.
ಓಕೆ ಸರ್.
ಆ ಡೇಟ್ ಇಂದ 15 days.
ಓಕೆ ಸರ್. A
ನೆಕ್ಸ್ಟ್
contract to do or not to do something if some event collateral to such contract does or does not happen is called contingent contract sir. ಇದು
ಏನಂಗಂದ್ರೆ
ಅಂದ್ರೆ ಇವೆಂಟ್ ಆಗ್ಬೋದು ಅಥವಾ ಆಗದೇನೆ ಇರ್ಬೋದು. ಕಾಂಟಿಜೆಂಟ್ ಕಾಂಟ್ರಾಕ್ಟ್ 31 ಸರ್, ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್.
ಕರೆಕ್ಟ್. ನೆಕ್ಸ್ಟ್
The magistrate, after finding the accused guilty, is of the opinion that accused ought to receive more severe punishment than magistrate is empowered to inflict, he shall submit the proceeding to the subordinate. ಇಲ್ಲ, ಇದು ಗೊತ್ತಿಲ್ಲ ಸರ್ ನನಗೆ.
ಇದೇನಂದ್ರೆ, ಈಗ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಒಂದು ಕೇಸನ್ನು ಟ್ರಯಲ್ ಮಾಡಿ ಕನ್ವಿಕ್ಷನ್ ಕೊಡೋ ಪವರ್ 3 years ಇರುತ್ತೆ. 3 years ಕೊಡೋ ಬದಲಾಗಿ 7 years ಕೊಡ್ಬೇಕಂತ ಅನ್ಸುತ್ತೆ ಅವ್ರಿಗೆ, ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ಗೆ. ಅವಾಗ ಆ ಕೇಸನ್ನ 3 ವರ್ಷಕ್ಕಿಂತ ಹೆಚ್ಚಿಗೆ ಅವ್ರು ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ವಲ್ಲ, ಅವಾಗ ಅವ್ರು ಏನ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಚೀಫ್ ಜುಡಿಷಿಯಲ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕಳಿಸ್ಬೇಕು. ನೋಡಿ, ಇದು 3 ವರ್ಷಕ್ಕಿಂತ ಬಹಳ ಗ್ರಾವಿಟಿ ಇದೆ, ಸಿವಿಯರ್ ಇದಿದೆ. 3 ವರ್ಷಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕಂತ ನನ್ಗೆ ಅನ್ಸಿದೆ. ನೀವು 3 ವರ್ಷಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕನ್ವಿಕ್ಷನ್ ಕೊಡಿ ಅಂತ ಚೀಫ್ ಜುಡಿಷಿಯಲ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕಳಿಸಿದ್ರೆ ಅವ್ರು ಕನ್ವಿಕ್ಷನ್ ಕೊಡ್ತಾರೆ. ಸೊ ಹಂಗಾಗಿ ಆನ್ಸರ್ ಚೀಫ್ ಜುಡಿಷಿಯಲ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಅಂತ ಬರೀಬೇಕು.
ಓಕೆ ಸರ್.
325 CRPC section.
Yes, 325 CRPC. Yes. Next.
Who among the following has become the president of India without becoming the vice president of India? APJ Abdul Kalam sir.
Yes. ಮಿಕ್ಕಿದವರೆಲ್ಲ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಿ
ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಿದ್ದಾರೆ ಸರ್. ಇವರು
ಪ್ರೆಸಿಡೆಂಟ್.
Yes sir. What must be the age of minor with regard to the offense kidnapping as defined under section 361 of Indian Penal Code? Under 16 years, 18 years, under 16 years if we are male, under 18 years of if you are female, under 18 years of male, under 21 years of female. Answer ಬಂದ್ಬಿಟ್ಟು C sir.
C. ಏನು ಈ C ನಲ್ಲಿ ಏನಿದೆ?
ಏಜ್ ಇನ್ ಬಗ್ಗೆ ಅಂದ್ರೆ ಈಗ ಹುಡುಗ ಅಥವಾ ಹುಡುಗಿ ಆಗಿರೋದು ಎಷ್ಟು ಏಜ್ ಅಲ್ಲಿ ಕಿಡ್ನಾಪಿಂಗ್?
ಹುಡುಗ ಆಗಿದ್ರೆ ಎಷ್ಟು ಏಜ್, ಹುಡುಗಿ ಆಗಿದ್ರೆ ಎಷ್ಟು ಏಜ್?
ಹುಡುಗ ಬಂದ್ಬಿಟ್ಟು 16 years ಸರ್, ಹುಡುಗಿ ಬಂದ್ಬಿಟ್ಟು 18 years ಸರ್.
ಎಸ್ ಕರೆಕ್ಟ್. ನೀವು ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಓದ್ಬೇಕಂದ್ರೆ ಇಷ್ಟೊಂದು ಫಾಸ್ಟ್ ಆಗಿ ಓದ್ಬೇಡಿ, ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ತೈತೆ. ನಿಧಾನಕ್ಕೆ ಹೋಗಿ ಆನ್ಸರ್ ಮಾಡಿ, ಹಂಗಂದ್ಬಿಟ್ಟು ತುಂಬಾ ನಿಧಾನ ಮಾಡಬೇಡಿ.
ಬಟ್ ತುಂಬಾ ಟೈಮ್ ಕಮ್ಮಿ ಇರುತ್ತಲ್ವಾ ಸರ್ ನಮಗೆ?
ಕಮ್ಮಿ ಏನಿರೋದಿಲ್ಲ, ನೀವು ಫುಲ್ ಪ್ರಿಪೇರ್ ಇದ್ರೆ ನಿಮ್ ಟೈಮ್ ಇನ್ನ ಉಳಿತೈತೆ.
ಸರ್ ನಂದು 2 ಸಬ್ಜೆಕ್ಟ್ ಇದೆ ಸರ್, CPC CRPC, ಅದಕ್ಕೆ ಲಾಸ್ಟಿಗೆ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ ಅವೆರಡು.
ಈಗ ಮಲ್ಟಿಪಲ್ ಚಾಯ್ಸ್ ಕ್ವಶನ್ ಪೇಪರ್ ಆನ್ಸರ್ ಮಾಡುವಾಗ
ಹ್ಮ್.
ಸ್ವಲ್ಪ ನಿಧಾನಕ್ಕೆ ಓದಿ ಆನ್ಸರ್ ಮಾಡಿ.
Okay, sir. President of India shall be elected by
ಹ್ಮ್
elected members of Lok Sabha, elected members of both Houses of Parliament, elected members of both Houses of Parliament and legislative assemblies of the state, elected members of both Houses of Parliament, legislative assemblies, and legislative councils of the states.
ಯಾವುದು ಆನ್ಸರ್?
C, sir.
ಸಿನಾ? ಸಿಲಿ ಯಾರು ಬರ್ತಾರೆ?
This both houses, Rajya Sabha and Lok Sabha and legislative assemblies of the state ಇರುತ್ತೆ ಸರ್.
54 sir article. Correct answer.
ಮ್ಯಾಮ್ ಆನ್ಸರ್ ಕರೆಕ್ಟ್ ಇದೆಯಾ ಮ್ಯಾಮ್ ಅದು?
ಅದು ಕರೆಕ್ಟ್ ಇದೆ. ಸರ್ ದ ಪ್ರೀವಿಯಸ್ ಒನ್ ಶಿ ಟೋಲ್ಡ್ ಅಬೌಟ್ ಕಿಡ್ನಾಪಿಂಗ್, ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ ಸರ್ BNSS ಅಲ್ಲಿ. ಏಜ್ ಸ್ಪೆಸಿಫಿಕೇಶನ್ ಇಲ್ಲ, ಬರೀ ಚೈಲ್ಡ್ ಅಂತ
ಅಂದ್ರೆ ಅದೇ ಇಫ್ ಇನ್ ಕೇಸ್ ಅದು
ಇಲ್ಲಿ IPC ಕೊಟ್ಟಿದಾರಲ್ಲ, IPC ಪ್ರಕಾರ ಇದೇ ಇರುತ್ತೆ.
ಇಲ್ಲ ಸರ್, ಮ್ಯಾಮ್ ಹೇಳಿದ್ದು ಬೆಟರ್. ಯಾಕಂದ್ರೆ ಈಗ IPC ಕೊಟ್ರೆ ಇದನ್ನ ಮೆನ್ಷನ್ ಮಾಡ್ತೀವಿ, ಅಲ್ಲಿ ಎನಿ ಏಜ್ ಅಂತಾನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಅದು ಕರೆಕ್ಟ್. ಇಲ್ಲಿ ಈಗ ಭಾರತೀಯ ದಂಡ ಸಂಹಿತೆ ಅಂತ ಕೊಟ್ಟಿದಾರಲ್ಲ, ಭಾರತೀಯ ದಂಡ ಸಂಹಿತೆ ಅಂತ ಇರೋದ್ರೆ ನೀವು ಇದನ್ನೇ ಬರಿಬೇಕು.
ಓಕೆ ಸರ್, ಬಟ್ ಏನು ಅಂತಂದ್ರೆ ಮ್ಯಾಮ್ ಹೇಳ್ತಿರೋದು ಈಗ ಹೊಸ ಸೆಕ್ಷನ್ ಆಗಿದೆ ಅಂತ ಅಂದು ನಮಗೆ ಮುಂಚೆನೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಅಂದ್ರೆ ಅವ್ರು ಮುಂಚೆನೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಈ ರೀತಿ ಇದೆ ಅಂತ ಅಂದು.
ಒಳ್ಳೇದು ಕರೆಕ್ಟ್.
ಅದಕ್ಕೋಸ್ಕರ
ನೆಕ್ಸ್ಟ್ 11th.
The Constitution of India adopted by the Constituent Assembly on 26th November 1949.
ಲಾಡೆ.
Answer.
ಲಾಡೆ ಅಂತ ಕೂಡ ಕರೀತಾರೆ.
Okay sir.
Next 12.
Which one of the following is correct as per the Code of Civil Procedure Code 1908? ಮ್ಯಾಮ್ ಇದನ್ನ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಬೇಡಿ ಮ್ಯಾಮ್ ನೀವು
ಹೇಳಿ ಮ್ಯಾಮ್.
ನಾನು ಹೇಳ್ತೀನಿ. Order 1 Rule 8 adding or striking out parties. Order 22 Rule 3 making legal representative of deceased plaintiff as a party to the suit. Order 22 Rule 5 making legal representative of deceased defendant as a party to the suit. Order 23 Rule 3 withdrawal of the suit with liberty to file fresh suit. ಕರೆಕ್ಟ್ ಯಾವ್ದಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಕರೆಕ್ಟ್. Order 1 Rule 8 deals with representative suits.
Correct.
Order 22 Rule 3 is correct. Making legal representative of the plaintiff.
This is plaintiff as party to the correct. Next Order 22 Rule 5.
Rule 5 making legal representative of deceased defendant as a party to the suit.
Wrong.
This is incorrect again.
Yes, incorrect. Next
Order 22 Rule 4 is correct.
3.
Order 23 Rule 3 deals with compromise.
Yes. With liberty to file fresh suit alilla. Idu wrong. Incorrect statement. Next.
So ivaga correct statement ಬಂದ್ಬಿಟ್ಟು ಮ್ಯಾಮ್ ನಮೀಗ Order 1 Rule 8.
Order 22 Rule 3 B.
Order 22 Rule 3. Okay.
Yes, correct. ಅದರೊಳಗೆ ಏನು ಹೇಳುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
Okay sir. As per section 137 of Indian Evidence Act 1872, examination of witness subsequent to the cross examination by the party who called him is called as re-examination, further examination in chief, further cross examination sir.
None of the above.
None of the above sir. ಇದಕ್ಕೆ
ಏನದು? Examination of a witness subsequent to the cross examination by the party who called him is called as
re-examination sir.
Re-examination. Correct. Next 14.
If any one of the 5 or more persons who are conjointly committing dacoity commits murder in so committing dacoity, every one of those persons committed offense punishable under Indian Penal Code. ಒಂದೇ ನಿಮಿಷ ಸರ್ ಹೇಳ್ತೀನಿ. 395 ಅನ್ಸುತ್ತೆ ಸರ್ ಇದು.
96.
ಸಾರಿ 396. If one or more. Yes sir, 396 sir, punishment.
396 is the answer.
Yes sir.
Yes. Next.
Code of 15 the CPC 1908 provides for granting temporary injection, perpetual injection, mandatory injection, all of the above. Temporary injection sir.
Correct madam?
Yes sir.
Temporary injection.
Perpetual and mandatory specific release.
Specific release ಬರುತ್ತೆ ಸರ್ ಅದಕ್ಕೋಸ್ಕರ.
Correct. Yes.
A leading decision of the Supreme Court of India on Section 65 of the Indian Evidence Act, admissibility of electronic evidence. Arjun Pandit Rao Kotkar versus Kailash Kushan Rao, Korantile and others. Gurubaksh Singh Sibia and others versus State of Punjab. Lalita Kumari versus Government of Uttar Pradesh and others. Harnesh Kumar versus State of Bihar. The right answer ಬಂದ್ಬಿಟ್ಟು ಅರ್ಜುನ್ ಪಂಡಿತ್ ರಾವ್ ಕೋಟ್ಕರ್ ವರ್ಸಸ್ ಕೈಲಾಶ್ ಕುಶನ್ ರಾವ್ ಕೋರಂಟೈಲ್ ಅಂಡ್ ಅದರ್ಸ್ ಸರ್. ಇದು
ಗುರುಬಖತ್ ಸಿಂಗ್ ಯಾವ್ದ್ರ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ? ಗುರುಬಖತ್ ಸಿಂಗ್ ಸಿಬಿಯಾ ಅದು ಅರೆಸ್ಟ್ ಬಗ್ಗೆ.
Blanket order with respect to anticipatory bail.
ಆಂಟಿಸಿಪೇಟರಿ ವೇಲು, ಅರೆಸ್ಟ್, ಡಿಟೆನ್ಷನ್ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ. ಲಲಿತಾ ಕುಮಾರಿ ಕೇಸು ಅದು ಕೂಡ
ಅರೆಸ್ಟ್ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ ಸರ್. ಇದನ್ನು ಲಲಿತಾ ಕುಮಾರಿದು
ಪ್ರಿಲಿಮಿನರಿ ಎನ್ಕ್ವೈರಿ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ. ಹರ್ನೇಶ್ ಕುಮಾರ್ ಕೇಸು ಅದು ಕೂಡ ಅರೆಸ್ಟ್ ಪ್ರೊಸೀಜರ್ ಬಗ್ಗೆ ಹೇಳುತ್ತೆ.
ಓಕೆ ಸರ್.
ಇದು ಇಂಪಾರ್ಟೆಂಟ್. ಹರ್ನೇಶ್ ಕುಮಾರ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಬಿಹಾರ್, ಇದ್ರ ಮೇಲೆ ಒಂದು ಕ್ವಶನ್ ಇದ್ದೇ ಇರುತ್ತೆ ಗ್ಯಾರಂಟಿ.
ಇದು ಎಕ್ಸ್ಪೆಕ್ಟಿಂಗ್ ಇನ್ 3 ಕೇಸಸ್ ಎಲ್ಲ ಅರೆಸ್ಟ್ ರಿಲೇಟೆಡ್ ಬರುತ್ತಲ್ವಾ ಸರ್ ಇದು?
ಹೌದೌದು, ಮಿಕ್ಕಿದೆಲ್ಲ ಅರೆಸ್ಟ್ ರಿಲೇಟೆಡ್.
ಓಕೆ ಸರ್.
ಅದೆಲ್ಲ ಗೈಡ್ಲೈನ್ಸ್ ಇದಾವೆ, 3 ಗೈಡ್ಲೈನ್ಸ್ ಇದಾವೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ. ಗೈಡ್ಲೈನ್ಸ್ ಒಂದ್ಸಲ ನೋಡ್ಕೊಂಡ್ರೆ ಯಾವ್ದಾದ್ರ ಬಗ್ಗೆ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ.
ಓಕೆ ಸರ್.
ನೆಕ್ಸ್ಟ್,
Visarim, an offence punishable under Section 354C of Indian Penal Code means monitoring the use by a woman of the internet, email or any other form of electronic communication. A man watching or capturing the image of woman engaged in private act, following a woman and contacting such woman to foster personal interaction repeatedly, making sexual colored remarks. Answer ಬಂದ್ಬಿಟ್ಟು B sir. A man watching or capturing the image of woman engaged in a private act, sir.
Yes, correct. Next,
when a decree passed against the government, execution shall not be issued on such decree against the government unless it remains unsatisfied for period dash computed from the date of such decree. 2 years.
2 years.
3 months.
3 months, ma'am.
3 months, section 82 ಪ್ರಕಾರ.
When a decree is passed against the government, execution shall not be issued on such decree against the government unless it remains unsatisfied after 3 months.
Okay.
3 months.
When the court permit the plaintiff to institute the suit against the government without serving notice under section 80 subsection 1 of the CPC, and court can grant interim relief against the government without giving opportunity of the showing cause. Court shall not grant any interim relief against the government without giving opportunity of showing cause. It is discretion of the court to grant any interim relief or not. Court can pass an ex parte order of status quo against the government. Ma'am, ಇದನ್ನು ಸ್ವಲ್ಪ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿ ಮ್ಯಾಮ್.
ಈಗ ನೀವು ಸೆಕ್ಷನ್ 80 ಓದಿದ್ರೆ, ನೀವು ಗೌರ್ಮೆಂಟ್ ಮೇಲೆ ರಿಲೀಫ್ ಕೇಳೋದಿದ್ರೆ ಫಸ್ಟ್ ಒಂದು ನೋಟಿಸ್ ಕೊಡಬೇಕು. 2 months ನೋಟಿಸ್ ಕೊಟ್ಟು ನಿಮ್ಮ ಹೆಸರು ಅಡ್ರೆಸ್ಸು ಎಲ್ಲ ಹಾಕಿ ನಾನು ಇಂಥದ್ದು ರಿಲೀಫ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಇಂಥ ಕಾರಣಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತೇಳಿ ಅದರಲ್ಲಿ ತೋರಿಸ್ಬೇಕು. ತೋರಿಸಿ ಕಂಪ್ಲೈ ಮಾಡ್ತಿದ್ರೆ 2 ತಿಂಗಳಾದಮೇಲೆ ನೀವು ಸೂಟ್ ಹಾಕ್ಬೋದು. ಅಕಸ್ಮಾತ್ ನೀವು ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ರಿಲೀಫ್ ಬೇಕಂದಾಗ ನೀವು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಈ ಥರ ಅರ್ಜೆಂಟ್ ರಿಲೀಫ್ ಬೇಕಾಗಿದೆ, ಅದಕ್ಕೆ ನೋಟಿಸನ್ನು ಎಕ್ಸೆಂಪ್ಟ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ಬೋದು. ಕೇಳಿ ಕೋರ್ಟ್ ಅಲೋ ಮಾಡಿ ಸೂಟನ್ನು ಅಡ್ಮಿಟ್ ಮಾಡುತ್ತೆ. ಇಲ್ಲ ಅಂದರೆ ಇಲ್ಲ, ಇಟ್ ಇಸ್ ನಾಟ್ ನೆಸಸರಿ ಟು ಅಡ್ಮಿಟ್ ದಿ ಸೂಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಅನ್ನೋದಿದ್ರೆ ರಿಟರ್ನ್ ಮಾಡ್ಬೋದು. ಪ್ಲೈಂಟನ್ನು ರಿಟರ್ನ್ ಮಾಡಿ ಆ ಪೀರಿಯಡ್ ಮುಗಿದ ಮೇಲೆ ನೀವು ಫೈಲ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೋದು. ಗೊತ್ತಾಯ್ತಲ್ಲ
ಸರ್? ಇದು ಆನ್ಸರ್ ಸರ್ ಈಗಾಗದೆ
ಇದಕ್ಕೆ ಆನ್ಸರು ದ ಕೋರ್ಟ್ ಶಲ್ ನಾಟ್ ಗ್ರಾಂಟ್ ಎನಿ ಇಂಟ್ರಿಮ್ ರಿಲೀಫ್ ಅಗೇನೆಸ್ಟ್ ದಿ ಗವರ್ಮೆಂಟ್ ವಿತೌಟ್ ಗಿವಿಂಗ್ ಅಪರ್ಚುನಿಟಿ ಆಫ್ ಶೋಯಿಂಗ್ ಕಾಸ್. ಅಂದರೆ ಅವ್ರು ನೋಟಿಸ್ ಕೊಡಲಾರ್ದೆ ಅವ್ರ ಮೇಲೆ ರಿಲೀಫ್ ಕೊಡಂಗಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ.
ಓಕೆ ಸರ್.
ನೋಟಿಸ್ ಅವ್ರು ಬಂದು ಅಪಿಯರ್ ಆದಮೇಲೆ ಅವ್ರು ಕೇಳಿ ರಿಲೀಫ್ ಕೊಡ್ಬೋದು ಅಂತೇಳಿ.
ಓಕೆ ಸರ್. ಓಕೆ.
ನೆಕ್ಸ್ಟ್,
the word satyameva jayate in the Indian national emblem is taken from Ramayana, Samaveda, Rigveda, Upanishad.
Yes.
ಮುಂಡಕ ಉಪನಿಷತ್ ಅಂತ ಸರ್.
ಮಂಡಕ ಉಪನಿಷತ್. 21, sir. Doing is an act which would bring the government established by law in India into hatred or contempt is called conspiracy, waging war against government, sedition, abatement. Sedition, sir.
Sedition.
Rajadroha.
Rajadroha.
Answer.
An offense against the state.
Yes, sir.
Next.
Section 215 of CRPC deals with following subject. Content of charge, effect of errors in charge, alteration of charge, a recall of witnesses when charge is altered, effect of errors in charge, sir.
Yes. Next.
As per order 14 rule, ma'am, really? As per order 14 rule 5 of CPC, the court may strike out the wrongly framed issues at any time before commencement of trial, at any time before conclusion of trial, at any time before pronouncing of judgment, at any time before passing of decree. Answer ಬಂದ್ಬಿಟ್ಟು ಸಿ ಸರ್.
ಸಿ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಕ್ ಮೊದಲೇ
ಮುಂಚೆನೆ
ಯಾವ ಚಾರ್ಜಸ್ ಬೇಕಾದ್ರೂ ರೀಫ್ರೇಮ್ ಮಾಡಬಹುದು, ಸ್ಟ್ರೈಕ್ ಆಫ್ ಮಾಡಬಹುದು,
ಸ್ಟ್ರೈಕ್ ಔಟ್ ಮಾಡಬಹುದು ಸರ್,
ಆಡ್ ಮಾಡಬಹುದು.
ಎಸ್ ಸರ್.
ಇಶ್ಯೂಸ್ ಅನ್ನು, ಇದು ಚಾರ್ಜ್ ಅಲ್ಲ, ಇಶ್ಯೂಸ್.
ಇಶ್ಯೂಸ್ ಸರ್.
ಎಸ್.
Next question. A let out his immovable property to B for manufacturing purpose. In the lease agreement, both A and B agreed that said lease is terminable by 1 year notice. But as per Section 106 of Transfer of Property Act 1882, lease for manufacturing purpose shall be terminable by 6 month notice. A can be terminate the lease by 6 months, sir. Answer is 6 months, sir. Answer is 6 month notice. Manufacturing purpose irodinda 6 month notice, sir.
Correct, madam?
Sir, previous idu
Really, ma'am.
6 months notice, sir.
6 months notice,
Answer.
Correct,
If in case ಸರ್ ನಾವೇನಾದ್ರು ಡೇಟ್ ಮೆನ್ಷನ್ ಮಾಡಿಬಿಟ್ಟು 1 year ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಅವಾಗ ನಾವು 1 year ತಗೊಂತೀವಿ. ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಪರ್ಪಸ್ ಅಂತ ಬಂದ್ರೆ 6 months, ನಾರ್ಮಲ್ ಬಂದ್ರೆ 15 days ಇದೆ ಸರ್.
By 6 months notice.
Answer.
Yes.
As per Section 10 of Indian Penal Code, word man denotes a male human being aged of above 6 years, a male human being aged of above 18 years, a male human being aged of 21 years, a male human being of any age. Answer ಬಂದ್ಬಿಟ್ಟು D, sir.
Of any age.
Any age.
ಮೇಡಮ್, ಒಂದು ಅದು 23ನೇ ಪ್ರಶ್ನೆ ನೀವು ಓದಿದ್ರಲ್ಲ, ಸ್ಟ್ರೈಕ್ ಔಟ್, ಅದು ಎನಿ ಟೈಮ್ ಬಿಫೋರ್ ಪ್ರೊನೌನ್ಸಿಂಗ್ ದ ಜಜ್ಮೆಂಟ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆನ್ಸರ್. ಎನಿ ಟೈಮ್ ಬಿಫೋರ್ ಪಾಸಿಂಗ್ ದ ಡಿಕ್ರಿ.
ಹೌದಾ ಮ್ಯಾಮ್?
ಹಾ, ನೀವ್ ನೋಡಿ ಕ್ಲೀನ್ ಆಗಿ, ಅದು ಸುಮ್ನೆ 1 marks ಹೊರಟೋಗ್ಬಿಡುತ್ತೆ.
ಕರೆಕ್ಟ್, ಯಾಕಂದ್ರೆ ನಾನು ಅದನ್ನೇ ಹೇಳ್ತೀನಿ. ಸಿಪಿಸಿ ಸಿಆರ್ಪಿಸಿ ನನಗೆ ಹೆಲ್ಪ್ ಮಾಡಿ.
ನೋ ಪ್ರಾಬ್ಲಮ್, ವಿ ಆರ್ ಆಲ್ ಲರ್ನಿಂಗ್ ಟುಗೆದರ್. ಈ ಫೈಲ್ ನೋಡಿದ್ರೆ, ದ ಕೋರ್ಟ್ ಮೇ ಅಟ್ ಎನಿ ಟೈಮ್ ಬಿಫೋರ್ ಪಾಸಿಂಗ್ ಎ ಡಿಕ್ರಿ ಅಮೆಂಡ್ ದ ಇಶ್ಯೂಸ್ ಆರ್ ಫ್ರೇಮ್ ಅಡಿಷನಲ್ ಇಶ್ಯೂಸ್ ಆನ್ ಸಚ್ ಟರ್ಮ್ಸ್ ಆಸ್ ಇಟ್ ಥಿಂಕ್ಸ್ ಫಿಟ್, ಅಂಡ್ ಆಲ್ ಸಚ್ ಅಮೆಂಡ್ಮೆಂಟ್ಸ್ ಆರ್ ಅಡಿಷನಲ್ ಇಶ್ಯೂಸ್ ಆಸ್ ಮೇ ಬಿ necessary for determining the matters in controversy between the parties shall be so made or framed. The court may also at any time before passing a decree strike out any issues that appear to it to be wrongly framed or introduced. The word judgment is not used.
Yes, decree, correct. D is the correct answer.
D is the correct answer.
Yes.
Thank you, ma'am. At any time before passing the decree, ma'am.
ಹೌದಮ್ಮ, ಹೌದು.
Thank you.
ಅದಕ್ಕೆ ಸರ್ ಹೇಳಿದ್ದು, ನಿಧಾನಕ್ಕೆ ಓದಿದ್ರೆ ನಾವು
ನಿಧಾನಕ್ಕೆ ಓದ್ತಾ ಇದ್ದೀನಿ ಅನ್ಕೊಂಡಿದ್ದೀನಿ. ಈಗ
ಅಲ್ಲಪ್ಪ, ಎಕ್ಸಾಮ್ ಟೈಮ್ ಅಲ್ಲಿ ಯು ವಿಲ್ ಲೂಸ್.
ಇವಾಗ ಓದಿ ಫಾಸ್ಟ್ ಆಗಿ.
ಸರ್, ಇದು ಮ್ಯಾಮ್ ಹೇಳಿದ್ ನಿಜ. ಅದು ಗೊತ್ತಿರೋ ಆನ್ಸರ್ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದೀನಿ. ಮಾಡಿದ್ದೀನಿ ಅದಕ್ಕೋಸ್ಕರ.
ನೋ ಪ್ರಾಬ್ಲಮ್.
ನೆಕ್ಸ್ಟ್ ಓದಿ.
A promise made without any intention of performing it is misrepresentation, undue influence, coercion, fraud. Answer ಬಂದ್ಬಿಟ್ಟು fraud, sir. Correct, ma'am?
Correct, ma'am. Correct.
Okay. Joke Falls, which is one of the highest waterfalls in India, is created by Tunga River, Kaveri River, Sharavati River, Bhadra River. Sharavati, sir.
ಎಲ್ಲಿದೆ ಅದು ಶರಾವತಿ?
ಶರಾವತಿ ಎಲ್ಲಿದೆ? ಶಿವಮೊಗ್ಗದಲ್ಲೇ ಇದೆ ಅನ್ಕೊಂತೀನಿ ಸರ್.
ಹಾ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಇದಕ್ಕೆ ಭದ್ರಾ ರಿವರ್ ಅಂತ ಹಾಕಿದ್ದೆ ಸರ್. ನಾ ರಾಂಗ್ ಆನ್ಸರೇ ಮಾಡಿದ್ದೆ ನಾನು.
ಹೌದಾ?
ಶರಾವತಿ ರಿವರ್.
ಶಿವಮೊಗ್ಗ ಸರ್.
ಶಿವಮೊಗ್ಗ.
ಶಿವಮೊಗ್ಗ.
ನೆಕ್ಸ್ಟ್ 28.
Yes, sir. Withdrawal of the complaint under section 257 of CRPC. A discharge of accused. Acquittal of the accused, either A or B or none of the above. Acquittal of the accused, ma'am.
Correct ma'am.
Okay.
Acquittal.
ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಅದಕ್ಕೆ ನಾನು ವಿಚಾರಿಸ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ CPC CRPC ಮ್ಯಾಮ್ ಹತ್ರ.
Yes.
The Specific Relief Act 1963 provides for granting temporary injunction, perpetual injunction, mandatory injunction, all of the above, sir. Idu.
Correct.
30. A makes an attempt to steal some jewelries by breaking open a box and finds after opening the box that there is no jewelries in it. A committed any offense. Committed answer B ಬಂದ್ಬಿಟ್ಟು committed an offense punishable under section 511 of Indian Penal Code. Committed an offense punishable under section 379 of Indian Penal Code. Committed an offense punishable under section 379 and 511 of Indian Penal Code.
ಯಾವುದು
ಸರ್ ಬಂದ್ಬಿಟ್ಟು
ಬಾಕ್ಸ್ ಓಪನ್ ಮಾಡ್ತಾನೆ ಚಿನ್ನ ಕತ್ಕೊಂಡು ಹೋಗೋಣ ಅಂತ.
ಹೌದು ಸರ್.
ಅಲ್ಲಿ ಇರಲ್ಲ.
ಹೌದು.
ಏನ್ ಮಾಡೋದು ಈಗ?
378 punishable.
511 ನೋಡಿ ಅದೇ ಕರೆಕ್ಟ್.
511 ಅಟೆಂಪ್ಟ್.
ಬಿ ಆನ್ಸರ್ ಮ್ಯಾಮ್ ಆಗರ.
ನೀವು 511 ಇಲ್ಲಸ್ಟ್ರೇಷನ್ ನೋಡಿದ್ರೆ ಇದಕ್ಕೆ ಆನ್ಸರ್ ಸಿಗುತ್ತೆ.
ಕರೆಕ್ಟ್.
ಓಕೆ.
ಎನ್ ಅಟೆಂಪ್ಟ್.
ಒಂದೇ ನಿಮಿಷ ಸರ್ ನೋಡೇ ಬಿಡ್ತೀನಿ.
ನೋಡಿ.
ಯಾಕಂದ್ರೆ ಅವ್ರು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಮೇಡಮ್ ನೀಟಾಗಿ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ತಾರೆ ಸರ್, ಏನಕ್ಕೇನು ಬರಲ್ಲ ಅನ್ನೋದು ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ ಸರ್. ಸರ್ ಓಪನ್ ಆಗ್ತಾ ಇಲ್ಲ, ಮೊಬೈಲಲ್ಲೇ ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಆನ್ಸರ್ 511 ಸರ್. ಬಿ ಆನ್ಸರ್ ಕಮಿಟೆಡ್ ಅಫೆನ್ಸ್ ಪನಿಷಬಲ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 511 ಆಫ್ ಇಂಡಿಯನ್ ಪೆನಲ್ ಕೋಡ್ ಸರ್.
ಇಲ್ಲಸ್ಟ್ರೇಷನ್ ಇರಬಹುದು ನೋಡಿ ಅಲ್ಲಿ.
ಇದೆ ಸರ್ ಇಲಿಸ್ಟ್ರೇಷನ್, ಮೊಬೈಲಲ್ಲಿ ಆನ್ ಮಾಡಿದ್ದೀನಿ ಸರ್, ಅದರಿಂದ ಓಪನ್
ಇಲ್ಲಸ್ಟ್ರೇಷನ್ ಸರ್.
ಓಕೆ.
ಎಸ್, ಇಲ್ಲಿಗೆ ಸ್ಟಾಪ್ ಮಾಡಿರೋಣ, ನಾಳೆ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣಲ್ಲ. ನಾಳೆ ಒಂದ್ 2 ಪೇಪರ್ ಕಂಪ್ಲೀಟ್ ಮಾಡೋಣ.
ಓಕೆ ಸರ್.
ನನಗೂ ಮನೆಗೆ ಹೋಗಕ್ಕೆ ಲೇಟ್ ಆಗ್ಬಿಡುತ್ತೆ, ಇನ್ನು ಆಫೀಸಲ್ಲಿ ಇದ್ದೀನಿ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು
ಸರ್. ಥ್ಯಾಂಕ್ ಯು.
ಬಾಯ್.